person. Good afternoon, everyone. It's a real pleasure to welcome you all to this inaugural conference, HURIPEC conference on human rights, peace, and social justice. You will see from the theme being the place of law and lawyers in the struggle for freedom and democracy in Uganda, but also from the very title of the conference, that HURIPEC is adding a third leg to its mandate, because HURIPEC is the Human Rights and Peace Center. But as now a 31-year-old organization, it's clear that we also need to think of another element. In addition to human rights and peace, another key component has to be social justice. Not just justice, not just legal justice, but social justice. Justice that makes sense to the people. Justice that responds to the needs of society. That every single citizen in society can see that in a particular case, justice has been done. Effective, meaningful justice. So really, in our next 30 years, HURIPEC is looking, or is really mindful about the need to center and foreground the concerns, not just of human rights, not just of peace, but also social justice. And that's the spirit of this inaugural conference that will be annual for the next 30, 50 years, long after we're all gone from the face of this earth. And in that regard, it's a privilege for us to have as our keynote speaker a person whom I'm sure you all know, Mr. Malay Mabirizi, who is with us today. Yes, you can acknowledge his presence. And also, we're also privileged to have, again, by happenstance, with us the newly elected president of the Uganda Law Society, His Excellency Isaac Semaka. And moderating today's session is our very own Mary Auma Imoy. And the rapporteur is Madame Lona Apoemungu, who is right there. So, the moderator will say some things about both Mr. Mabirizi and also about Mr. Semakade. But I'd like to also say a few things about both gentlemen and how their work and their ideas have a certain special resonance with the work of HURIPEC and the theme of today's conference. Mr. Mabirizi is known as the rule of law champion. His name is on so many cases that we teach, and that I'm sure a number of you from the legal community, both students and practitioners, are aware of. We read the cases that have his name. We teach them, we read them, we interact with them. So he has struggled through a lot of the issues we think about, talk about. He has been at the heart of a lot of those issues. But he has been at the heart of those issues in a way that does not talk about the things that, for me, made me very sad about the Uganda Law Society for a long time. Where you attend the ULS AGM and your hearings talk about business, and you wonder whether you are at a company annual general meeting or at a meeting of the Uganda Law Society, properly so called. So the issues Mr. Mabirizi has been, and his approach to law, and the simplicity and the human touch he brings to legal practice, not as a celebration of the kind of clients, the big clients, so with a high turnover of billions. No, it doesn't present usually the way it seems law practice presented as a competition over type of car, type of house, residence. No. He has deliberately approached law from the spirit of the human being, the spirit of the common person, which is what law should be, which is what the struggle for freedom, democracy, which is what the rule of law should be about. Human beings, common people, abantu, the human being. That's what law should be about. And watching his struggle, watching his fight, watching his relentless pursuit of that vision should be what a law student aims to be, should be what a lawyer aims to be. There's nothing wrong with making money. But if the pursuit of money becomes the sole overriding ambition of a law student or a lawyer, there's something then very poor about that law student, something very poor about that lawyer, something very mean and small about that vision of law. But we've also seen Mr. Mabirizi suffer for his pursuit of justice. We have also seen him pay a very serious price for his approach to justice. And today, as HURIPEC, we choose to identify ourselves with that struggle because we see the suffering Uganda went as the inevitable suffering that any person who really pursues justice in the Uganda of today will inevitably go through. And again, for me and for us as HURIPEC, that discussion is an important one to have. That if in an abnormal time you're okay, then there's something, then you're doing something wrong as a lawyer and as a human being. If in an abnormal time you're not being arrested, for you as a lawyer, you're not being arrested, you're not suffering in any way, haven't suffered any tear gas, haven't gone to prison a bit, then there's something you're doing wrong. And that, as I say all those things, I'm reflecting upon myself, that I have to ask myself, what am I doing wrong? Why is it that in this abnormal time, I haven't yet been arrested, tear gassed? So again, it's a conversation with you, but also a conversation with myself. What am I doing wrong? To see that I'm moving around normally in an abnormal situation. And really, we are excited to hear from Mr. Mabirizi today about the place of law and lawyers in the struggle for freedom and democracy in Uganda today, because I can think really of no better person to talk to us about this very issue than Mr. Mabirizi. But the moderator will tell us more about it. But the newly elected president of the Law Society, so in a sense, they are like twins also, and I know there are some twins in the audience, but these two gentlemen are like twins in a sense, because their vision, their philosophy of law is very similar. A couple of days ago, we organized a debate here in the thick of a campaign for the presidency of Law Society. As HURIPEC, we sent the invite to the three candidates for the ULS presidency. It was the same simple invite. It was a simple invite sent via WhatsApp. Two candidates responded and said, "Thank you very much for the message, we shall be there." One candidate did not even acknowledge the message. Instead, when the debate was proceeding, about 40 minutes afterwards, we received a letter from the candidates campaign team, sent from the letterhead of a law firm, saying that you sent us an invite via WhatsApp, how could you? How could you invite us via WhatsApp? And that in any case, the debate is against regulation, something of certain rules or whatever, where, the Law Society president can only campaign to members of. It was, for me, it was sad reading that letter from someone who sought to lead the Uganda Law Society, which is a public-facing body supposed to guide the state about the role of law, about the place of law in society. To then argue that because the debate is open to non-lawyers, then somehow that debate is illegal and may lead to disqualification. That letter for me made for very sad reading. But the two people who responded to that WhatsApp informal invitation, one of them was Mr. Isaac Semaka. But we also got to know, because it was brought to our attention, that there was that regulation. So I put it to the two gentlemen who had accepted the invite. I say, gentlemen, I won't want the HURIPEC debate to be the reason for your disqualification. This regulation that says any person who engages the debate, So I really put it to them. I say, if this is what's going to disqualify you, by all means, we can cancel it, or we can call it a public lecture, and then you come and we find a way around it. And I even called Mr. Semaka, and he said, why are you being a coward? He said, why are you being a coward? Mr. Gomba, why are you being a coward? Why are you bringing cowardice to this process? And I tried to demonstrate with him. I said, we're trying to for the greater good, let us, But those words stuck with me. Why are you being a coward? But he had more to lose. And to his credit and to the credit of Mr. Kipalu, they say, we are coming. You organize the debate, we are coming. And we accept the consequences. And again, for me, that was a very important moment to see two people who had a lot to lose in terms of disqualification say, we are willing to come to the debate because of what it represents, because of the very idea of freedom itself, the very idea of the law society and what the law society represents. We shall come, and down be the consequences. That was legal rebellion. And that is the rebellion that we need in Uganda today, where the laws are themselves increasingly abnormal, increasingly unjust, increasingly immoral. So in jurisprudence we ask, is a bad law a real law? Is an unjust law a real law deserving of obedience? From that moment I understood who I was going to vote for. I was going to vote for a person who has the fortitude to rebel against a bad law. The thought came to my mind that if as a presidential candidate you don't have the courage to rebel against a regulation, a simple regulation like this, not even a statute, not even an act of parliament, just the regulation has made you fear, and you're writing letters to say, I'm not coming because of this regulation. What will you do when there's an act of parliament? Where will your voice be when there's an actual act of parliament? And God forbid, where will your voice be when the very constitution itself, when now there's an actual constitutional amendment? Friends, it's not my day to speak. I'm among the organizers. It is my day to keep quiet. But I thought it was important to put in context why we're having this conference, but also why we have these two gentlemen in our midst today. It's because they have demonstrated an ability to face bad law, to face bad process in the eye and say, no, not today. Down the consequences. And ladies and gentlemen, I suggest to you that these are the kind of lawyers we should aspire to. This is the kind of lawyering we should aspire to. Not the safe kind, not the convenient kind, not the normal kind in an abnormal situation, not the kind of big who has survived tear gas and arrest so far, not the safe kind, but that kind. And with those, unfortunately, I don't plan to say all that, Madam Mary, but with your forgiveness and my apologies for taking that long, I give way to the moderator. Thank you so much. And
thank you so much, VK, for orienting us really to the purpose of the conference that we are having here today. A lot has been said about our keynote speaker. I'm not even sure that I can add anything of value to what Dr. Kawumba has stated about our keynote speaker. But before I invite our keynote speaker to say something, I also just wanted to bring to your attention what our program for the afternoon is going to look like. So we will have the keynote address, and thereafter we shall also have an address by the President of the Uganda Law Society, and then we shall open up the floor for discussion for a plenary. That's when we'll have an opportunity to ask your questions and to contribute to the discussion. Then we'll see where to go from there. So, like I said, a lot has been said about our keynote speaker this afternoon, but let me try also add just to, to drum it further, to lead it home. So, our keynote speaker this afternoon is a lawyer, a litigant, and a civically active Ugandan. And in the pursuit of human rights and rule of law, social justice, governance, he has litigated severally and in the interest of the general Ugandan, in the interest of the general public, in the interest of the general Ugandan citizen. He has litigated nationally. He has been to every court in this country, and he has not stopped there. He has gone further to the East African Court of Justice in pursuit of these principles, the very principles that HURIPEC stands by. The cases he has litigated are too many for me to mention this afternoon. You know them, and I think each of you could name a case, and then you'll be like towards the back of the room before the case is run out. So he has done a lot of litigation on human rights, on governance, on peace, on all sorts of things. And I'll not mention the cases that he has dealt with. He has been referred to as the rule of law champion. Some people have even referred to him as the GOAT of rule of law for his bold and unfiltered interpretation and application of the law. He has litigated against individuals, against institutions, against systems, against laws, against policies, against everything that threatens the justice, threatens peace, threatens human rights in this country. And ultimately, he has paid for this sacrifice with his own freedom, as you are aware. So let us please give a warm round of applause to welcome our keynote speaker, Mr. I invite you to now take the floor.
Thank you so much, Madam Moderator. Is it safe here? So it can be. Thank you so much. I have about 30 minutes to present for this conference. But I think, Doctor, I'll need more 10 minutes to make this, to bring everything home. So I want, I've been introduced, but I'm the one. I'm the one that is stronger. I know, being at law school, when you used to read the cases, this versus this, Mukwaba versus Mokubira. You couldn't imagine that Mukwaba maybe was younger, maybe used to live. You think that Mukwaba maybe was a very old man. When you used to read expert matter, you think, well, who was this man? Was he? So I'm the one, Marina Benizi. That's it, I'm here today to present a paper. Keynote speech, actually. The place of the lawyers in the struggle for freedom and democracy. Now, fellow citizens, we now start. I will say citizens and all in attendance because they are online. Before you meet me, my name is Strong. A self-styled civically active Uganda. That is ordinary resident in Uganda. Now that definition has jurisprudence in the East African Court of Justice. The reference number 6 of 2029, the agreement case. So I'm delighted to address you on this eve of Uganda's 62nd independence, which is tomorrow. So in this speech, I'm going to address you on 15 aspects. I'm going to address you on the invitation, how I was invited here when I was in the Supreme Court of Justice. I will address you on the law, purpose versus use in Uganda. I'm mindful of the title the doctor chose and his team. It is a complicated title that we shall handle. Then I will address you on the common Ugandan's understanding of the lawyer. Then I will address you on the meaning of freedom and democracy. Then I'll talk about the lust for power and wealth by lawyers. Then I'll talk about the Abomayanja as our choice as opposed to Inaugural or bench one. I'll tell you that ours is a constitutional and a traditional duty. I'll also tell you that our 1994 constitution has since been replaced. Then I will address you on what shapes Semakademali's work methods. I'll address you on the sovereignty takes precedence over judicial independence. I also tell you that Second and J uses content of the court as a shield from public criticism and scrutiny of the judiciary. Then I also address you that I'm happy Ugandans have capacity now to intimidate judges. They intimidate in that single court. I also tell you that Uganda judiciary is tired of citizens' litigants, and then Uganda lawyer judges are bothered by none of courts. And then I'll conclude. So I think by the end of the day, this topic will be addressed in reality and in law. So the invitation found me in the East African Court of Justice, and I'm thankful to Dr. Kabumba, the director, for the invitation. Of course, he didn't tell me I gave him a hard time for many reasons, which I'll highlight. One, I do not want to be an academic of sorts. That's why I didn't want to come to university. Rather, I want to take actions and spend less time on deliberations. And that part explains why I rarely accept media interviews and programs. To convince me to appear in your program, because we are not commentators, we are actors. It is a few, it's a fourth match, we are players. So as actors, when I was invited, I was in Arusha, Tanzania, for East African Court of Justice, September, October 2024 session. Now, on my way to Tanzania, I went through Kenya, Milimani High Court, where on 13th September 2024, I attended High Court of Kenya session, case number E436 of 2024. That is also out of Kenya, which now is one case in Uganda, versus Inspector General of Police and others. In that case, Mugambi J sentenced Kenya Inspector General of Police to 6 months imprisonment. That was a serious decision. I attended it. So on this African Court of Justice cause list, I had cases from 17th September to 2nd October. It was a marathon. I had cases against 2 partner states. The first one is Uganda. Uganda, in East Africa, is 2 partner states, organ of the state. In Uganda, I was challenging Museveni's blockade of Sebuya and Taylor on X or Twitter. I was challenging the Child Administration Act 2020. I'm challenging Parliament acting below Quran during COVID-19 lockdown. I'm challenging the March 2020 Museveni lockdown, the closing down of Parliament and courts, appointment of JF Abodo as DPP, and Joke Musingu as Commissioner General, the Revenue Authority. I also had cases against Kenya. Now, on the causes, there are 2 cases against Kenya. In the first application, Kenya Attorney General was seeking for amendment of her response to the reference. That reference is 39 of 2022, Malema the First Attorney General of Kenya, where I'm challenging the declaration of William Ruto as President-elect of Kenya. So, Attorney General, it's a serious matter, but because of time, we will need to go into details. But briefly, democracy in one partner state affects other partner states. So, a resident of the community can challenge that election, and I did. So they had an application, they want to amend their defense. They feel their defense is not strong enough to win me. In another matter, the Independent Electoral Commission of Kenya wanted to be allowed to intervene. They want to be interveners in that case. Now, in the first one of amendment, I won and I was awarded costs because they had made an improper application before the court. So that you will also see that in the media of Uganda, because I told you we are actors, we don't spend too much time. So apart from Arusha, my schedule after Arusha, Tanzania was equally very tight. On my way back by road, of course I had to go by road because there's no money, but that doesn't stop us. I had to stop by Jinja High Court to check on two cases. The first one is a criminal case 764/2023. That is Uganda versus Gawula, ASC, Kazimba, and Najinda. Over that 2023 fictitious marriage ceremony. There's another cause in Jinja, 2024, against Attorney General of name of Dr. Crispus Shionga as Chancellor of Makerere University, without recommendation of the Council, conduct section 30 subsection 1 of the Universities and Branch Districts Act. So, Doctor, I was challenging your course. So on Monday, 7th October 2024, yesterday I had to appear in Memo Court on miscellaneous courts number 176 of 2021 and 2022 against my paternal relatives over an Indian family allowance. Now, today before I came here, I had to be at Anti-Corruption Court at 9 before Judge General Kajuga in appeal number 9 2024 against refusal by federal magistrate to summon parliament staff, who is Sokore, Atiro Daniel, Emmanuel Karajab, on money laundering charges are opened against them, over 6 million shillings they received, which I consider to be rounded. So you can see. So now I'm here. But now on 10th, the day after independence, I will appear in Constitutional Court. That's petition 36 of 2022 against Kabako of Uganda, Attorney General. Now, the dispute there is Kabaka's holding out as a landowner, as opposed to a trustee, as provided for under Article 246 of the Constitution. Now, on 10th, we will be scheduling application number 4 for discovery of documents. So, Doctor, that's why I had to disrobe. Allow me to look at it. I don't know, we are here. Now, the law, purpose versus use in Uganda. Now, I have found the most realistic definition of law from Roscoe Pound, as produced in Black's Law Dictionary, 8th edition, at page 258, those who can access it. That definition is that law is an idea of a rule laid down by a lawmaking organ of a politically organized society, deriving its force from the authority of the sovereign. Now, we know that in Uganda, our sovereign authority is the citizens. In Uganda's supplier case, from the Supreme Court of Justice, you will find the citation in my, I'm going to provide this in soft copy. They stated that, paragraph 55, that the principle of rule of law entails that nobody is above the law. Everybody is held accountable under the same laws, and the law is applied equally to all citizens. The law is safer than individuals and organizations, law is supreme. Even people who enforce and administer the law, such as the police officers, judges, you see judges sometimes think they're above the law, and lawyers, are still subject to the same laws as everybody else. The rule of law limits the arbitral exercise of power by a single person or group. Dr. Abazinda. So there's no doubt that the law is the engine of good governance. When you look at that definition and the jurisprudence, the law is the engine of good governance because it provides an organized and predictable system. Now, the European Court of Justice Judge, Thomas Vaughan, if you find the citation of this article, stated that the concept of good governance is self-evident. It needs nothing else but common sense to be understood. It needs nothing but common sense to be understood. Entrepreneurs, this is very important. Entrepreneurs We will not invest in unstable countries. And people, whether entrepreneurs or not, will not wish to live there if they can afford to go elsewhere. So the law and its enforcement is important to determine the economic life of the country and also whether you attract investments and others. So that is the law as a principle and its purpose and how it ought to operate. Unfortunately, the reality in Uganda now is different. As ably stated by Professor Nwabuz of Nigeria in his book, Constitutions in Emergent Nations. It was reproduced by Professor Kanyehamba in Semoge University General, Oceanic Number. He said, in a number of developing countries, constitutions are perceived by those in power not as protectors of human rights and liberties of the individual, but as instruments for legitimizing the exercise of power. In terms of the government's legitimacy to exercise arbitrary power, to impose unreasonable laws, arrest and detain persons whose guilt is often highly suspect, to impose restrictions on certain freedoms and rights, and to do whatever the ruling oligarchy means. So in reality in Uganda, the inherent powers of the law is twisted, is arm-twisted to serve the rulers of the time, as we later see. So what is a common Ugandan's understanding of a lawyer? Because the title states the place of the law and lawyers. So I've addressed you the law. Now the lawyers. How does a common Ugandan understand a lawyer? And I like the way the framers of the topic chose the word lawyers. Why? It depicts the common understanding of Uganda. For Uganda, your styles of advocate, state attorney, prosecutor, magistrate, judge, barrister, solicitor don't matter. They all know you as lawyers. Now we also know students. The public doesn't know whether actually when you quote the bill, they say lawyer. You're a lawyer, I'm a lawyer. So whether you finish or not. Whether if you're being a student, it becomes an issue. If you're being a lawyer. So now, personal experience, in my first year at law school here, when I visited my stepmother, I just said she's at Uganda. She asked what I was studying. And on answering law, he said, Ogenda Kubamunas, you are going to be the judicial office. I said not necessarily because not every lawyer becomes a judge. She told me no, all the same. They are all lawyers and they relate and work together. She told me of a case she had in court, and the judicial officer was easily talking to lawyers, sometimes without them as parties knowing what was going on. To her, those on the bench normally connive with those at the bar to commit what we normally call judicial fraud. That is the common understanding of my stepmother. Secondly, the common Ugandan fears law as a profession in two dimensions. The first dimension is that expressed by Adet, the connivance. When they see you, they see money back. You will connive and somehow take away my property. Now another dimension is the hardship in studying law. Again, personally, in December 2005, in my high school, senior 5 holiday, my late father asked which course I was to go for university. I answered law. He asked, will you manage it? So he feared the law course. His fear being that I would fail to attain the qualifications he had admitted. When I answered yes, he said, let us pray for you. So my father had to pray for me to be admitted at Makerere School of Government Sponsorship because of the fear he had in me being admitted to law school. So I did not disappoint him. I scored 25 points and I ended up in law school at that point. Now, my late father held a pre-independent certificate in secretarial studies, which made him obtain a job from Asian companies, rising to the rank of general manager. That I told you about is also a pre-independent, semi-educated woman. So accordingly, both of them passed the test of a reasonable person, as stated by Justice Kapoor in our agreement case. That's a short He said that in the context of this country, a reasonable person is probably one who has a national identification card, a mobile phone, listens regularly to radio, attends LC meetings, has a job, or tends to his garden or business, works on Bodaboda town, or takes your children to school. So my parents took me to school, and I think they are far above the average definition. So that's how they understand lawyers. So we must put that now in the perspective today. So what is the meaning of freedom and democracy? Still keeping on top of it, right? I quote, "By personal freedom, I mean the freedom of every law-abiding citizen to think what he will, to say what he will, and to go where he will on these lawful occasions, without let or hindrance from any other persons." That is by Sir Alfred Benedict, and the book called Freedom Under the Law. You find the citation. In his article, The Role of the Judiciary in the Promotion of Democracy in Uganda, Ben Ketunomugisha, yes. So he wrote this in 2009 at pages 4 to 5. He said, "Democracy may be taken to mean the form of government in which the supreme power is vested in the people and for the people. Democracy demands that the government should be open, accountable, and participatory. The people take part directly or indirectly in the formulation of policies." He said democracy is not merely the right to vote and seize power. It also entails respecting, promoting, and protecting fundamental human rights and freedoms. And I like his definition. Democratic governance is a universal principle to which Uganda is bound. And the Supreme Court of Uganda has held so, specifically Odero, just of Supreme Court, in the Onyango case, that's Koshona to number of. Just Odero said that there can be no barriers of democratic societies. When the framers of our constitution committed the people of Uganda to the democratic society, they made democracy as universally known. So that story of in our Uganda way, you cannot have democracy in Uganda way. You see, in Charles Onyango, the state was saying, no, you cannot allow judges to lie. How can you state all of falsehood and say it's acceptable in Uganda? The judges that are saying that's the universal standard. It's okay to publish false news. Yes. So in Doctors, yes, it's okay. In Doctors for Life International, First National Assembly, it's a South African decision, number 12, 2005. Ngogo just said that we should read that decision at paragraph 110. It says, "The international right to political participation reflects the shared notion that a nation's sovereign authority is one that belongs to its citizens, who themselves should participate in government." And I think our constitution, under this paragraph 1 of the Democracy Policy, brings out that we participate in leadership at all levels. So plainly, I have been asked to analyze the role of lawyers in ensuring that Ugandans decide on who to govern them, participate in their leadership, live freely within their country, even after dissenting from rulers of the day, among others. And I think I'm up to task. Now, I address you on the lust for power and wealth by lawyers, and where most of you aspire to come. Most of you just, I think we still think in money terms. When I give the law school, I must be rich. Now, in our analysis today, we are to examine why lawyers who come from pre-mob students, in order to be qualified, are going to end up between Ugandans who trust them to uphold their freedom and rule of law. Of course, not all. Okechukwu, in his article, Seeking Justice for National Societies, again you find the citation, said that the attainment of justice represents the enduring promise of constitutional democracy. More problematic for citizens who seek justice is the fact that judges, driven by lust for power and wealth, often align themselves with the rich and the powerful in society to frustrate the search for justice. Now, in this address, being on Independence Eve, I'm going to analyze one by one 3 lawyers who managed to participate in governance of Uganda, both prior to independence and post-independence. The first one is Godfrey Binaisa Chusi. Chusi Binaisa was born in 1920 and earned a Bachelor of Laws degree in 1955 at King's College London. Now, in Ricky L. Binaisa, this is at 1959 East Africa, 1997. It is reported in that report. An advocate practicing in Uganda was arrested upon a warrant reciting that he was a person against whom proceedings under the Retribution Ordinance were pending and was remanded in custody. So he was arrested before independence for fighting colonialism. He was lucky on independence to become the first Attorney General and participated, unfortunately, in sanitizing the unconstitutional abrogation of the 1962 Constitution and convincing the expatriate judges then, because in 1966 we didn't have any Ugandan judge on the bench, all of them were foreigners. But he convinced them, in expert of the case which you know, that using force to capture power is permissible, hence undermining the freedom and democracy you have defined. So he participated in a situation described by Justice Kakuru, that petition. That I quote him. Mr. Obote, without holding any elections, became the president of Uganda and the Legislative Assembly, whose term was due to expire in 1967, self-extended the terms of president as well as theirs for another 5 years. Approved and adopted the 1967 Constitution, the same being placed in a pigeonhole of each member at Parliament. That to crush any political opposition through operation of basic rights of the people, particularly by use of international civil emergency in Uganda, and then detaining political opponents by use of detention law, which courts of law having no power, with courts of law having no power to question that detention orders. Now, all that was work organized. A lawyer who fought for independence. So the lawyer, who was imprisoned by colonialists, is now himself at the center of disenfranchising Ugandans and ensuring that they are laid without consent. So he deviated from the known principles of freedom and democracy. In 1968, Binaisa resigned after disagreeing with President Obote over detention powers under emergency laws. However, it was too late for him, since his earlier actions were ripe for a result, described by Justice Kakuru in that decision that among his young leadership was Colonel Idi Amin, whom Obote had relied upon for his acts in 1966 and 1967. On 25th January 1971, Major General Idi Amin took over government. Plainly, Binaisa Chusi laid the foundation to take over for Idi Amin. He got power, yes, which he later resigned. He got the wealth. I know Binaisa owned the whole of the in his name, in Kampala City, but his actions and legal opinions are still paid in Uganda. That is the first lawyer. The second lawyer is Abubakar Kacha Mamayanja. Abubakar Kacha Mamayanja was born in 1929 and dismissed from Ben Makerere University College, where we are here, over a riot strike in 1952. He resumed studies at University of Cambridge, United Kingdom. Now, as a member of Parliament on independence, he vehemently opposed the 1967 Pigeonhole Constitution. He is quoted by Justice Kakuru as follows. 1. He said that we should not change our constitutions in the way some maintain their shares. The Constitution should be a document of great sanctity. We should respect it and should abide by it. 2. We are not here to govern this country like savages. We are not going to reject the standards which have been accepted by the rest of the civilized world. We are not part and parcel. We are part and parcel of the civilized community. We are not going to justify autocracy and grant dangerous powers on the grounds that Uganda is backward and cannot have a civilized government. These are extracted from the answer when they were passing that Inaugural Constitution. He said that it was disappointing that even those rights and freedoms which were enjoyed in colonial times were going to be taken away by the present proposals. Finally, said that ultimately, democracy did not rest in the Constitution, but in the hearts and minds of the nation. So this thing that when you have a Constitution, I have democracy, there is a Constitution. Now, my has told them in 1967 that it goes beyond that. Now, his criticism of the 1967 Constitution continued. And his article in the Transition magazine, that is the April 1968 issue, made him charged with his edition in October 1968. Mayanja was acquitted, but he was rearrested under emergency laws, making him to spend 2 years at maximum security prison in Upper Brazil, where he myself served 18 months between 2022 and 2023. Same can be listed in you, and you couldn't access me. There's a burglar glass there, don't speak to me. We use a phone call, hello, how are you? So that's the maximum security prison upper kind of sky in Uganda. So Mayanja was there, just like me. I've not been able to know which ward and room Mayanja resided when he was there. But for me, I was in ward 8, room 1. Those who are going there know where it is. Now, throughout his career, I have not seen any report of him deviating from principles of freedom and democracy. He did not get the power as such. Mayanja did not get the money. He lived a humble life at Longoja, Kampala City, and another home at Kuribaki Division. But we are here to cherish his contribution and principles. He never lived in the upscale Kampala. The third lawyer is Benedict Chwanka. Thank you. Chwanka, my namesake, was born on 8th May 1922. He was called the bar by the Grace in London in February 1956. In 1962, Ben Chwanka's Democratic Party was rigged out by Uganda People's Congress, UPC, Kabaka Yoka Alliance. Now, you will ask, how do you know he was rigged out? Now, this rigging was relayed to me by late Honorable Manzi Tumuwaine, a former UPC youth winger, and later Minister of Trade in 1997 and Privatization in 1998. Manzi told me that he was fired from privatization rocket after he disagreed with Museveni on selling of UCB, Uganda Commercial Bank. Manzi was chairperson of Managers Association of Uganda Limited between 2017 and 2018, while I was general secretary. So I have no doubt his story. We were working together. He's now Moneylenders Association of Uganda Limited. So just like myself, Ben Chwanka ended up in Maximum Security Prison, Rosira, Upper, in 1969, until January 1971, when Okoto was removed. Now, the biggest contradiction of his freedom and democracy principles came on 27th June 1971, when Chwanka accepted to become a Chief Justice under Idi Amin Junta. I am up to now puzzled how Ben Chwanka, a Democrat, thought that democracy and freedom would flourish under military junta. Because the military moves in the opposite direction with democracy. As said by Babatun, you see citation in his article 2015. He said that the military emphasis is on discipline and obedience. Democracy places premium on non-conformity and freedom of thought and expression. The emphasis in democracy is on constant question of authority, discussion of issues, and consideration of policy options that are non-violent and respectful of the lives of others. The military addresses the extreme and the extraordinary, while democracy addresses the routine. The military values discipline and hierarchy, democracy, freedom, and equality. The military is related to law and order, democracy, diversity, contradiction, and competition. The method of military is violent aggression. That of democracy is persuasion, negotiation, and consensus building. So there is no way Ben Chwanka would actually manage to juggle both democracy and militarism. So it was unfortunate that this contradiction placed Ben Chwanka in a clear target of both the junta and its opponents. That is why those against Idi Amin say he abducted and killed him, while those in favor of Amin say he was a victim of sabotage by the elements like Museveni's foreigners. All the same, we lost pain at the age of 50, more painfully without the grave. Now that takes me to Abu Mayanja, why Abu Mayanja is our choice and not to be nice about each one. The three we have discussed, we are choosing the middle one, Abu Mayanja. The reason I carefully selected the above three lawyers was to paint a picture of today's lawyers, including your income. Many of them are after power and money, and they do not mind the impact their actions have in the country. Now, most of you fall in that nice group. And when you read those cases of experts, you praise him, but the man argued. So the man comes and starts arguing proud, but you say at least at the end of the day he won. So others are good at preaching democracy and freedom, but when offered incentives like bail to a court or being released from prison and being appointed Chief Justice, they deviate from the principles. Now the third category where I belong is standing on universal acceptable principles, no matter what, even if I stay without money. That is my understanding. And last time I closed the two prize at December 2023, now senior council president Carlos said, this is where I also belonged. I didn't talk to him 5 years here, so I don't know. So the jurisprudence on Abu Mayanja style is written in the decision of the Court of Appeal. You can read the civil application 549 Malema is vice president. It is dated 19th August 2022. At page 48, these judges are saying there is no legal right vested in a contemner, that's myself, to be released, save on the pardon of the court that committed him. They wanted me to seek pardon, to go for second and seek pardon, so that I can get out of prison. Now, this ruling came on in August. My prison sentence was ending in February 2023. But this was a formal communication. Many formal communications have been made earlier, but I apologize and get freedom. I refused, and I served up the next year in February. And I think now that is the Abu Mayanja case. And I think Sema can designed a t-shirt when I came back, no apology. Because he came to Africa and he said, these guys are options. How do we get out of here? I told him I'm not dying to get out of here. I'm dying to stand by my principles. This unillegal imprisonment charge should be dealt with by the law. So, but that is part of the price we have to pay, as Dr. Kawaman said. The democracy has a price, as stated by Justice Yamgisha, acting Justice of the Supreme Court in the Inaugural case I referred to, Appeal number 2022, 2002. He said that democracy, by its very nature, comes at the price. So he was telling the state that one of the prices of democracy is publication of false news. So democracy, the price for me partly by that was time. So I now proceed to tell you that ours is a constitutional and a traditional duty. Of course, this is where most of you are asking. Now, how do you benefit? We are serving a constitutional and traditional duty. Now, the main reason why I want to come here today is a duty imposed upon me and you, because the motion says every citizen, under several provisions of the Uganda Constitution. Let us start with the preamble. The preamble says, recording our history, which has been characterized by political and constitutional instability, recognizing our struggles against the force of tyranny, oppression, and exploitation, do hereby solemnly adopt, enact, and give to ourselves and our posterity, that's very important, this Constitution. So those words of posterity, citing where it came from, have a traditional connotation rooted in African succession, that a struggle of one generation is passed on to for another generation for continuity. In Uganda, we say Oscar. So when you come here, you carve on. So myself, just like many of you, is a product of such struggles by our ancestors who consistently opposed monarchical despots. Yeah, Uganda had many wars, some of you are joining you. They are opposing monarchical despots, they opposed slave trade, they opposed colonialism, and they opposed post-independence despots. The consequences of their struggles, both positive and negative, are alive with us. But I'm going to talk about myself. Of course, you relate to your own self as to how it applies. The founder of my Kobe clan, Namwamba Sero Karamazi, was a rebel who ran into exile in Bugisu, with which was a commander. They organized and came back and removed the then Uganda king Bimba. So many years back. My great-great-grandfather, Musilu Nomo, rose in arms against Captain Uganda administration under command of Prince Mugogo. They were forced to exile in Chibungu to Tanganyika, but later at a time when the freedom of religion was guaranteed, their struggle was freedom of religion. So they rose in arms. Now, during 1940s and 50s, my other grandfather, Kasim Male, who was named after me, whom I was named after, questioned why. Yes, I'm Kasim Male. Questioned why none of Uganda Kingdom ministers was a Muslim. He was later named the first Muslim minister in the colony of Inaugural. When Idi Amin took over, my paternal uncle, Seroko Daniel, who was then an assistant commissioner of police, raised concerns about democracy and freedom. Idi Amin killed him by firing squad on 9 September 1977. That's where it is. So upon fall of Idi Amin in 1979, his press secretary, who was my cousin, my auntie Anishi, was son to my auntie, never been married, was forced to exile. When Museveni went to the bush in 1981, my late father, Basil Semtuma, questioned Museveni's intentions. When Museveni captured power in 1986, gunmen said to the Bureau of Government raided his farm factory in Nagoji, Uganda district. Him being absent, they shot dead 4 workers, 3 being his relatives. He chose to hide at my mother's place at Legacy, now Uganda district, until when the situation normalized, when Alice were invaded from the east at the end of 1986. For those who know, who did not know, my birthday is 2nd January 1987, so you can relate. After almost a full year of hiding, so this man got a child from that hiding, from political persecution. So you should not be surprised when you read I'm going to High Court application number 112 by judgment of, that is Moses Solomon Male versus another versus Malema, which is a family DNA case. These siblings of mine don't know that my mother was their father's safe haven. That's why some of them never saw her. So, those who understand African traditions, you know that we almost have no option but to follow our ancestors' calling upon their successors to continue with the struggle for freedom and democracy. That's the duty we are performing here and elsewhere. So I will also refer you to paragraphs Roman 19F of the Uganda Constitutional National Objectives and Action Principles of State Policy, which says that it shall be the duty of every citizen to promote democracy and rule of law. Now we read that together with Article 3 sub-Article 4B, which says that all citizens of Uganda shall have the right and duty at all times to do all in their power to restore its constitution after it has been amended according to provisions. Now, there is emphasis to do all in their power. This article does not say peacefully, no, all in their power, because every situation will give you the mode of operation. If a junta comes, how do you remove a junta peacefully? So the framers knew. And then another point is amended according to these provisions. The constitution can be abrogated through an amendment according to these provisions. That takes me to our 1990 constitution as since been replaced. The emphasis, as I told you, is on the points amended according to these provisions in Article 3, sub-Article 4B of the constitution, because that has been done in 2005 and 2017. The constitution was amended according to these provisions, triggered military arms to do all in our power to restore it. Legally, upon 2005 and 2017 amendments to remove term limits and age limits respectively, the original 1990 constitution went into what Carlos Panero is an author. I've put there the citation, is an author from South America. He calls it constitutional replacement. He states that a constitutional amendment is a constitutional replacement if it replaces an element defining the identity of the Constitution. Now, the two amendments replace two key identity elements in the 1994 Constitution: sovereignty of the people and the qualification or capacity of the president of voting of honor. The framers of the provisions of the Constitution designed them well aware that they were talking about a president who was neither too young nor too old and had a term of only 10 years maximum. they never designed it for a lifetime president. So I'm saying that removing age limits and term limits undermine over 86 provisions which depend on the president and sovereignty of the people. Hence replace the constitution and how the republic is stored. What you have now is not the constitution as enacted by the people in 1995. Now, what shapes Semakademali's work methods? It is the earlier discussed understanding of lawyers by citizens that shaped mine and now develops at the present senior counsel and Semakad methods of legal work. Purposely, to change the public's understanding of the place of lawyers in society and to showcase how lawyers can contribute to democracy and freedom in a method understood by all. By all. Now, in 2018, we agreed that the age limit constitutional act number of 2018 should be delivered to Supreme Court at a pickup. So the pickup, people understood the rest of the constitutional matters when there is somebody on that pickup. So these are the deliberate strategies to achieve a purpose. In 2019, we agreed to launch open fundraising for the South African Court of Justice for 2019 and to continue generally. Now to trigger the people's duty to defend their constitution and fight for rule of law. So that, because how long will we keep waiting for foreign donors up to where? What if what you are chasing is against their interests? Donors may want a different to stock on sometimes. Now citizens starts to say no, we don't want it. Now the third one came to Rasta hairstyle is put in order. Now that Rasta hairstyle, I think started in 2021 around there. I asked him why. His explanation was that law should stop being seen as a profession for a given day sport. That young people and all walks of life should be encouraged not only to study law, but also participate in legal affairs. And I think I agreed. Right now, I think that now, even my Buddha friends says, I told him, I can't do about you. So, yes, even these things are also not lawyers. So at least the picture of the law and the lawyers as entitled is brought out. So these are deliberate strategies to ensure that the picture of lawyers and the law changes so that lawyers can take their seat in freedom and democracy. So that we run away from the lawyers of denials who are known for coming to argue fraudulently to win the day. So I now move on to sovereignty takes precedence over judicial independence. I now move on to judicial. So I'm saying sovereignty takes precedence over judicial independence. I quote, it is better that a man should not be brought to justice at all than that justice should be done to him without the public being given an opportunity to see it done. That is a quotation from B for versus R, 1960 East Africa, and 1965, specifically page 968. Now that quotation, I cited it in my letter of 26 September 2019 to Honorable Judge Flavia Senova Angry. That letter was titled, "What are you hiding from the public in Dr. Seda Nyanzi's appeal, where Museveni is the complainant?" In that case, there was a lawyer, but it's me who wrote, because I had come to attend and the judge was frozen close. Now, a judge cannot hide under judicial independence to run away from public scrutiny, as it was rightly held by Professor Chirukubinza in Agnew University in Achibole. That's Professor in 2016. She said that judicial accountability is crucial to judicial integrity. So judicial accountability is very important. Let's talk about independence. We want accountability from you because we pay you, we hired you. Judges cannot be independent of the people who are sovereign authority under Article of the Constitution. Sovereignty depends to us, so you cannot say you are independent of us. Actually, as it was stated in the case of Justice Carl Pada was Resource Commission, that's the Kenyan Court of Appeal case, number 2016. It is stated that in exercise of their sovereign power, the people of Kenya can do virtually anything they wish, including abolishing the judiciary. Yes, you don't want to hear it, but citizens can abolish the judiciary if they so wish under Article 1. So citizens who can abolish the judiciary must be respected by the lawyers therein, and that's the essence of Article 1.61, when it says that justice shall be delivered in the name of the people. Benjamin Odoki, former Chief Justice, wrote a book. We will see its title, but at page 34, said that people were concerned about injustice brought about by corruption, bribery, and sympathy towards the rich. This was in the constitutional making process. That's why Uganda said, no, we must be accountable to us. So, of mutual independence and sovereignty, I'm saying that sovereignty reigns high. That's why you see us checking these judges. That's why you see us, what Samaka says, we bank tables before them. Because we are higher than them, not them being higher than us. I move on to second J. Using contempt of court as a shield from public criticism and scrutiny of the judiciary. As you are aware, I'm a respondent in 2 High Court decisions carrying the same number. High Court Civil Division Listeners Court application number 8/2021. Our general versus myself, Marimanis, where I was ordered to pay a fine of 300 million shillings on 7th January 2022, and later on 15th February to serve with in-month imprisonment. Now, since the topic involves law and lawyers, this is an important case, since the prisoner, prosecutor, and the judge were all lawyers. It is important. So we are lawyers from different categories of lawyers. It's important to analyze the facts of and see when they are in order to understand whether the men and women at the bench are performing what Chief Justice Odoki said of them as custodians of the Constitution, guardians of the basic human rights and freedoms, and promoters of the rule of law. Or they are enjoying lucrative jobs with expensive cars, bodyguards, health insurance, namely, they have a very benefit. In ruling number 1, that's the 27th January 2022. Second as stated, I'm just going to quote. Exponential growth in use of online tools and social media has resulted in new challenges for the justice system. It will be gross contempt to impute judges of the court acted extraneous considerations in deciding the case. No one can be allowed to terrorize or intimidate the judges. Then an order that the respondent pays a fine of 100 million shillings. A strong warning were issued. Now, on 15th, the second ruling, which arose from 2 letters. I was imprisoned on letters, not of motion, but letters, 2 letters, under the hand of Chiwachiwanuka, as Attorney General. The ruling came on 15th February. Briefly, the second as stated. They said that receive attacks in the letters and tweets intended to analyze the court and intimidate the interpretation. However stupid or useless an order may appear, it must be obeyed. This one I disagree. This is a country of laws and not of men. The court ought to deter future attacks on the judiciary by early preventive action. The poisonous flow unhindered may eventually destroy completely the stream of justice. The respondent's tweets are intended to destroy the judicial system with systematic attacks on the judicial officer. The respondent should be arrested and imprisoned for a period of 18 months. Now, without delving into the unconstitutionalities and illegalities in the process of decisions, keeping by our topic chosen by Dr. Kawano, please do not lose it that these are the words from a lawyer, a former lecturer who got a job of a judge recently in 2018. He said, criticizing him and a colleague is contempt. He orders for my arrest and imprisonment at the same time, or in my absence. Now, I think these 2 decisions summarize the title of the address in relation to the content current situation, the place of the law and lawyers, the struggle of freedom and democracy in Uganda. I told you we have lawyers at the bench and at the bar and elsewhere. So I'm happy that Ugandans have capacity to intimidate judges. Intimidate is in civil court. From the background of second and he and the judiciary sound really intimidated by our litigation social media style and use the same word that we are intimidated. That's why I was imprisoned for intimidating them. Now, that is a step in good direction to asserting our sovereignty at home. Gone are the days when judges' only fear of backlash was from the state. Now, citizens also can lower and judges fear. So, judges must fear citizens because the citizens are the sovereign authority of this nation. The South African Court of Justice, judges led by Monica Mugenyi then, of course from Uganda, they also felt threatened actually by myself. In literally 6 of 2019, they said that page 71 about 151 that should that modus operandi have been deployed to exert any manner of pressure, blackmail, or threats upon this court, that misadventure has most certainly the necessary futility. So Monica Mugenyi is admitting that actually there are new tactics of dealing with the judiciary rather than the state. He says blackmail is pressure, what and what. At page 72 she said, the court is alive to today's reality that external interference with the influence of the judiciary is not a prism of the state. So we are moving closer. Judges must now fear us as opposed to fearing the men with the gun. So, what am I saying? Citizens must actively compete with the state to ensure that the judiciary rules in favor of common sense. Common sense in the judiciary can only be achieved when citizens participate, and in that we are invoking Articles 1 and Article 61 of the Constitution. Now, Uganda judiciary is tired of citizen litigants. Now, upon failing to give citizens appropriate answers to their legal questions, Uganda judiciary has decided to close these doors now from litigants. They started by amending the judicial rules in 2019 to state that the only person to sue is one with sufficient interest, something which does not exist in the Judicial Act. Through this trickery, they have dismissed our one High Court Civil Division Samples 27/2021, that is Philip Odoki, against Capital Markets Authority approval of MJ Environment Shares Sale. Mobiru dismissed Commercial Court Samples 84/2021 against Revenue Authority, pardoning MTN of taxes despite the presence of the tax appeal decision. And in Mbale, Lubega Faru acting judge, so important to say that he's an acting judge because he may not be confirmed. Just like Justice Bokura came off. He dismissed causes 29 and 2023, where he was challenging Uganda police ban of national platform and FBC rallies, and also Parliament referring to the committee. They are saying the citizen has also an interest to challenge such. And I'm hopeful that the Court of Appeal and the Second Court will overrule this nonsense. In the Court of Appeal, that's the case I told you. Civil Application 549/2022, when I was in prison. Chibet, Mudiabo Nanduswat, you go to pages 46-47 of that decision. They say the rule does not deal with specific litigants that are habitual litigants and file cases accompanied by numerous applications. In this jurisdiction, they go about their vexatious business unhindered until they hit a legal impediment, as the contemner, that's myself, in this application did, because now I was in prison. They said the Chief Justice should consider the gravity of this matter and make rules under the Civil Procedure Act to provide for restrictions on litigation by vexatious litigants. So we are at a level where judges are not concerned about what is before them. Now they want to say who is before us. So now they want to close the gate. who has come? My name is no. Didn't just that. But we should not sue you. So this is where we are. So second last is that the Uganda lawyer judges are bothered by non-advocate lawyers. Now every generation comes with its uniqueness. In ours, which I may be a pioneer, it is unique being a lawyer, but not an advocate. Hence, not subject to the Advocates Act and regulations made there. Although at first it was viewed as being problematic, since no income will work on an advocate, I have disproved them by making money a non-issue, but using the legal knowledge to file and argue cases personally. This angered them. At one time at Supreme Court, our Judge Arvanga said they would make laws to forcefully regulate me, and I just laughed. Monica Mugenyi, now at Supreme Court in Uganda, when a principal judge of Court of Justice, in that reference number 6, she said at pages 7 to 71, paragraph 149, that the record revealed that Mr. Mabilis is not an advocate and therefore not subject or apparently aware of the ethical standards the Capital Hill Advocates Act of Uganda. The dire need for an ethical code that delineates acceptable professional conduct to which lawyers that do not fall within the ambit of advocates can be held to account would not be overstated. So it's now jurisprudence. They want non-advocates to be regulated. And we are saying yes, we now have them. How do you regulate me when you don't give me practice license? When I don't practice, you are regulating me for what? But the reason is they fear a civically active citizen and a lawyer who can come and add himself. You cannot tell him that I'm going to suspend your PC, I will file law counsel, but he can bang the table, sometimes abuse you, sometimes follow you, and the only thing you can do is prison. And they are saying now prison is no more. We are about prison maximum security for a full year. Not a natural to go. So conclusion. From the discussion, it is clear that the majority of lawyers habituated Ugandans as far as application of law to democracy and freedom is concerned. They seem to be more concerned with power and wealth. Now allow me to conclude with two passages from the decisions. The first one is by Odell, the late Justice Odell, then he was Justice of High Court, in constitutional case number 1 of 1987. Center of Abasa General. He held that in view of our recent history, governments in Uganda should follow the rule of law in exercising legislative and other powers. To do so is a necessary process in developing a return. That's what 1987 rule of law had collapsed. A return to the rule of law, which has been conspicuous in this country in breach rather than in observance by governments and citizens alike. So the duty to promote the rule of law is both on the government and you, the citizens. The last passage is from Odinga versus Uhuru, that is Kenya Supreme Court Presidential Petition number 2017. You look at page, paragraph 394. They said, the Malagaleti panel said that greatness of a nation lies not in the might of its armies, important as that is, not in the largeness of the economy, of its economy, important as that is also. The greatness of a nation lies in the fidelity to the Constitution and strict adherence to the rule of law. Another passage I know of read is from Nisaje, former Person of Justice. He said that the main difference between developing countries and developed countries is adherence to the principles of rule of law. So if you want your country to proceed and move on, just apply the rule of law, the rest will come. I rest my case. Thank you so much.
I think that our keynote speaker has done great justice to the topic before us today. I could say that I'm personally inspired to find out what this maximum security prison looks like, the upper one, room 1. 182, yes. It has been an excellent address, surely. For me, I picked out a lot of things, and I'm sure you did too. But I'll just maybe reiterate very, very briefly what stood out for me in his address. First and foremost, it was the clarity with which he related the different, extremely relevant principles that as lawyers and law students we have to grapple with to be able to achieve freedom and democracy using the law. The principles of constitutionalism, the constitution itself, principles of democracy, of freedom, of rule of law, all of which we should use together, jointly and individually, and interpret together to be able to really make our mark as lawyers in this country. I also really appreciated the history that he relied on, and while he gave his address, it became increasingly clear to me, and the saying that goes that the past is not dead. In fact, it's not even past, because where we are here represents where we were before, and indeed is a guide to where we will be in the future. So it was very, very important for him to make that clarification, to make that connection, to be able to indicate to us where we are coming from as lawyers, who we are, from not having a legal fraternity, a Ugandan legal fraternity, or maybe from not having Ugandan judges in the 50s and the 60s, and now having so many judges and magistrates and so many distinguished members of the bench, and then we on the other hand as members of the bar and as lawyers generally, you know, what is our role given the history that we have as a country, and what must we do as lawyers to, you know, to represent what we stand for, really. So for me, that's also something that I picked up. Importantly also is the fact that being the kind of lawyer that fights for freedom and democracy and the rule of law and constitutionalism and social justice calls for us as lawyers to make conscientious decisions, for us to be committed, because it is not enough for us to have the law existent in the constitution, in the laws, in the rules, in the principles, but beyond that, far and beyond that, as lawyers, we have to express a commitment to furthering these aims, to furthering these principles that we stand by, and the commitment has to be made either mentally or at heart or wherever, but then it can be demonstrated then in our acts, in what we do then towards furthering that. And so for me, as I go away this afternoon, the question I'm going to ask myself yet again, like Dr. Kabumba did, is what type of lawyer am I? Come 2025 or 2026, am I ready to get in prison to further these principles? Am I ready to, you know, to fight, to go to the trenches, as we say? Is it something that I'm ready to do? You know, based on everything, based on the experience of someone who has done that for the past 10 years, and also based on the round of applause that you have given, because you also agree with what he has said. So come 2026, let's see where, if we shall meet in the trenches. But yes, so as I communicated earlier, we are going to now have an address from His Excellency, Senior Counsel Isaac Semakade, the President of the Uganda Society. He has denied me the opportunity to properly introduce him and tell you all about the struggles that he has had, you know, the rebellions that give him his name as a legal rebel. He has denied me this opportunity and said, no, today we are dealing with the law, we are taking away individualism, and we are dealing with the matter at hand. And for today, the only thing that is relevant is that I'm the president of the Uganda Law Society, and that is all you should say. So please, you're welcome to take the floor.
The Director, HURIPEC, Dr. Kabumba, faculty present, our distinguished guest of honor and keynote speaker, my comrade Hans, and lifelong partner in this conspiracy, radicalize the Uganda bar, members of the School of Law, guests, members of the public, with us for this auspicious occasion. I'm so grateful for your audience today. It's a very emotional moment. Mavis and I have contemplated this small honor for a long time. Not that we work for these things, but we work towards a moment where the lawyers of Uganda, the institutions of Uganda, would recognize the Mabilis moment, would come to this moment on their own. And when I noticed this advert for HURIPEC, I felt cheated. I felt cheated, and I have discussed with Dr. Kawumba that there is a very perfect anecdote to explain why I felt cheated. In the year 2020, sometime in April, during the pandemic, I received a call from an unknown lawyer called Banado. He was running for president of Uganda Law Society, and I laughed at him. I said, "You are a non-entity at the bar. You are running for the office that is already occupied by Mr. Male Mabilis. He is the president of the Uganda Law Society." You're seeking a vote from somebody who doesn't have it. For this office, we already have an occupant. You can go to the public and ask. The citizens of Uganda are already awake to the Malema village moment, except you. Maybe for the sake of running for a title and a sinecure, maybe. But the office already has an occupant. And can we discuss how you will work with Mabilis if elected? That call took nearly 4 hours. For those who have called me before to discuss law, this is normal. So I was grateful for Bernard staying on the call for 4 hours and to receive radical talk of that kind. And so he won my vote on 2 occasions. Of course, I didn't vote that first election, 2020, and he lost by 9 votes, so maybe my vote would have counted. But he had the wisdom to return again for the same office in the year 2020. But this time, he had confessions to make. The first confession is that I was right. There is a clan and gang at the bar that lives and swears by rule of law, and had he permitted me to lead his campaign, had he permitted me and Malema to lead his campaign in the first run, he would have made it across the vote, across the threshold by far. But he had asked us to support him from behind. So this time he was saying, I want you to do so from the front. I want you to invite your clan and gang to my candidacy. And I campaigned from the front, and he won by a landslide. That gave us a barometer of where lawyers and Ugandans were in acknowledging the Malema Village moment. But Oundo being Oundo, couldn't help denying us the little reward we sought, a moment of his kind, to provide Malema Village a place at the bar, to speak to us about his craft, his grit, so that we can learn something without being forced. Because there was a lot of narratives out there about Malema Village, which he has explained within the institution of the law, the institutions of the law, the courts, LDC, law council, police, office of the Attorney General. There are many. They all deal with Malema Village daily. But there was this deception that we can erase him in conversation as lawyers. So Bernard led office from September 2022 up to September 2024, ignoring Malema Village. By some happenstance, I picked nomination forms and ran for this office to replace Bernard, hoping that one of the first things I would do is to create a Malema Village lecture under the auspices of Uganda Law Society. But HURIPEC has beaten me to it. So when I heard that it's happening, I made sure that I should be among the first attendees, and it gave me great honor to see the surprise on my director, that Somakane was seated among the audience, waiting to receive learning from a lawyer of Malema Village caliber. I am very humbled and very pleased that you have presented a first class inaugural lecture on human rights, peace, and social justice. Dr. Sinje Kawungu, you have no date with the Law Society. My Vice President is here. Please stand up for recognition. We should reward, I will implore our council to reward Dr. Kawungu with lots of waivers, lifetime waivers, for giving us this historic moment. It is truly historic, if you listen to it. I'm sorry, because of the work we do, when we speak about this work, it causes tears. Trauma takes over. So I must now learn to speak with some stronger metal than before. But it is impossible to celebrate Malema Village without being authentic. We are proud of you. We are proud of you, Malema Village. It is no measure of health to be perfectly well adjusted to an abnormal society. Yet lawyers, by their legal training, are trained to be perfectly adjusted to abnormal situations and abnormal societies. And Malema Village has used 3 examples of lawyers who are iconic for our journey as a state, and shown this distortion and invited you to reject formalism and normalism and be perfectly adjusted to madness during abnormal society, in the face of abnormal laws. Reject decorum. Reject even being a lawyer and just be a damn good citizen. I will give a few anecdotes of my Malema Village story. I first heard of Malema Village in a little known case that Malema Village doesn't talk about, because it brings him perhaps some embarrassment, or maybe it showed him the enormity of the challenge. But Malema Village made the perfect response to that case which he lost. It is called, as all cases are called, Malema versus the Attorney General. The department of the Attorney General, the client department in that case was law counsel. Malema was challenging pre-entry rules. Not because he wanted to join the Law Development Center, but because he felt they were unfair. They were irrational, they were out of bias. Whoever had made them, the same paperwork committee, lacked jurisdiction, they lacked authority to do so. But Malé had put that paragraph that he doesn't wish to join this. So lots of arguments were focused on his lack of interest in the penultimate one. And I think the case was dismissed for that reason. Why should we hear the rest if you don't want to benefit from the outcome? We were not close then. But as Malé can take solace, Parliament intervened and stopped that nonsense. There are some people who hold high office who think we should return, but we should remind them that the sovereign authority rejected pre-entry at LDC. And it falls upon you who are still here to fight that battle. As Mabili said, never scab. You are the heirs of that struggle. Don't sit back. After that case, I used to argue a number of cases in the civil division and the constitutional court, and I would see this person who observes me persistently in the gallery, making copious notes, during proceedings. And well, I thought those are his rights, but I never really reached out to talk to him. I would just do my work and leave. And then I learned later that he was engaged in very hotly contested litigation against the Kabaka of Uganda. I learned this through my former employer, who reached out to me in a fit of panic, seeking authorities to defeat Malema. I had to apologize and say, I'm sorry, I can't help. Malema has just asked me for similar authorities to defeat you. And I have given them to him, so I don't wish to engage in somersaulting and assisting both sides. The case involved delay by the Kabaka to exercise traditional judicial authority as the Supreme Court, the apex court in the traditions and culture of Uganda regarding the Kobe clan, which had a dispute over its apex leadership. And Malé had joined law school when that case was there. He had left law school when the case is still before the Kabaka, and he sued for a singular declaration that the Kabaka's delay exercise apex authority, apex judicial authority within the institutions of Uganda is a violation of human rights and the Uganda Constitution. And he wanted a court order to direct the Kabaka to act with expedition to solve the vacancy in the titular leadership of the Kobe clan. I wonder why a lawyer or lawyers thought there was anything to argue. Luckily for Malema, there was a lawyer that stood up for him, the now retired late Justice Foguli. But Malema did achieve this win, which is not talked about. This is his first win. Some people say he doesn't win cases. I was very close because both sides came to me as the shrine master. So, before Malema gets this win, he had to ask for the recusal of every other judge in the civil division. and we had 5 judges. Those are 4 recusal applications. That tells you the kind of resolve, the kind of backbone, the kind of bullshit meter that Malema has. And you have to admire something about that. That stuff is not taught. Courage under fire is not taught in law school. It comes from somewhere, which I think time did permit. But there's a wonderful interview he gave some obscure reporter who found him in his element. I think somewhere in the Entebbe courts, he was fighting with Mujingo or something, and they told him to wait for a ruling. So this reporter was able to get an exclusive into what the Baganda called Jemvude. To really tell me your origin story, and maybe he gave his origin story to that particular reporter. He said, an exclusive. If you can find it, you will get to understand where some of this courage was manufactured. He was facing fire because a very articulate brother of his, Pastor Male, was telling one version of his origin story. This man sued his father when he was a child. He's no good. He sued his father again after university and came to ask for a court order to have his father imprisoned as a civil debtor because he had didn't pay his debts. So, as you can imagine, his own brother was casting him as some sort of ogre, Shrek. He's a Shrek figure. He's a Shrek figure. Why do you? So this journalist humbly put these accusations to him, and Malema will say, "Let's find a chair, and I tell you, my origin story." I think Dr. Kabumba and our guests today, that is another contribution I can make to this story. It involves some effort going through YouTube debris, but I'm sure it's there. Do you know the reporter or the link so that it can simplify work? In YouTube, yeah. YouTube. Yeah. I know it's not wicked, but would it give such an exclusive wicked? He gave it to a citizen journalist. Yeah. He wouldn't do that. I know him enough to know that. And I'll tell you why along the way. So anyway, let me then move on to our first real conversation. At some point, he got the confidence to approach me and criticize me directly in post-mortem. Just after the judge has walked out or during the break, he would say, "This is where you're failing. If you can take it this way and take it that way, we can win." Because he understood that much of our work at Legal Brains Trust or the Center for Legal Aid was for the public. So he understood himself. He was there to hold me accountable as a member of the public in whose name we are doing this litigation. And of course, I will take these instructions. I think it was the case of Wembo Habib versus Katolwama, an extra commission, where a simple citizen called Wembo Habib, and now a very recognized figure in citizen activism, had brought us something of a political potato. There is a rule in the electoral laws that a month after gazetting of who won the parliamentary elections, the courts will not receive any other election petition. Habib came 6 months after, and he had moved through lawyers. This is a very important case for this topic. He had moved through, a bevy of lawyers saying, "I have proof from Katolwama's twin that Katolwama is not who he says he is. He didn't even go to school." So according to Wembo Habib, this is a true story, because he was brought to my office, and he said he has in his company at his home. I know that he has Waswa, and he's keeping Waswa under safe custody. so that we can. He's looking for a lawyer who can get him a date with a judge, so that Waswa can give testimony against Kato. So that Kato didn't go to school and shouldn't be in parliament. It pained me to ask, how long have you kept Waswa? And he said, we are entering 2 months now. So I said, I don't think that's how the law works. We don't need Waswa. We need information from legal institutions. So I introduced Wembo to access to information. And you never did disappoint. I never forget the article, the title from Bukit Day, sometime in the year 2016. It was titled, you never put them. That is the day I became a celebrity. I used to use taxis, walk easily and what, but after that day, that's when I understood that Ugandans love their celebrities. I became haunted by a group called Solidar. Incidentally, I was taking a taxi. I used to live in Rwanda, and some of these people were discussing the same market. Who wants to take away their Mwaka? And I was just among them. That's when I knew that we like to use authentic pedagogy, but I must start to use Uber for my own safety. Because if these people realize that that's the same, they would finish me that day. So, during that case, Mavis got closer because the case was really urgent in the traditional finance lawyering sense. Justice Oguli stood out. Not once for Malema Ministry, but for me too. Because she agreed with our arguments. And she used a very simple argument. Are you telling me that was addressing a long line of lawyers that if the woman MP for Kampala turns out to be a man, I am blocked by this law of limitation? You know? Are you telling me that I am powerless to defend the sovereignty of the people? So when Mabili speaks of judges as custodians of sovereignty, he is speaking from lots of moments, you know, of vivid battle, where the clash was no longer personal, it entered the heart of doctrine. That case was highly publicized through YouTube and everything. Like I said, I became a celebrity in that case. So Omulongo, may his soul rest in peace, he gave us a fine moment to do good justice. And when the case came to the appellate court, incidentally, the jurisprudence became worse. So, but we shall leave that for the law journal. After that, I felt that Mabili's criticism of my talent and presentation had been helpful. I owed him an audience. We had built a fraternity now. We could be brothers. I invited him to our Center for Legal Aid, which used to be a teacher's house on Gombo Road, closer to students and market vendors and border riders, so that we are centered in the community. We invited him to discuss a number of things, the most important being our understanding of his moment, of Sika, to be specific. I told him that it gives me great honor and pride to speak to you as the person whom I shall pass the baton viva what do you call it in law? During life. Intervivals. Yes. That's Mr. Mabini. This is an intervivals experience. I have never desired to be the sole person people hate. So I'm here to receive you formally into hatred and ridicule. And I am selfish about this. Told him, my name is, I'm going to do everything it takes to ensure that you are more hated than I am. But I will also pass on some of the lessons and reflections which I feel I should have received before I entered this business of managing public disputes in the name of the public against lawyers and using legal institutions, the struggle for freedom and democracy for this post-colony. The first thing we shared and put to his table was fundraising. I told him that Malema Muzi, you stand at a fantastic moment in our journey, in our struggle for freedom and democracy in Uganda. You have just won a case against the Kabaka of Uganda to have access to his treasury, to scrutinize his books of account, to scrutinize his bank accounts, and the entire franchise of power is against you. Now, again, Malema had moved 4 recusal applications to find a judge who would issue him that application. So when Malema tells you that judges are in a conspiracy against him personally, and people like him, they want to make an example of him, decapitate him, impoverish him, so that there's no other person who ever thinks of being a social activist. So that law students don't think about any other vocation except being an advocate. Because an advocate is an important weapon and tool in the struggle for freedom and democracy. So they know this. And they know that Mabirizi's style had brought potency. It had subverted everything. So I told him, well, you have, and on the heels of this case, you have done another thing. You haven't rested. You haven't allowed yourself a celebration. You have moved on to file a petition against the age limit amendment. And you are the star of Bali. When you think about all the footage, all the noise that came from Bali during the hearing of the constitutional petition, everything else is forgotten except 2 things. Number one, that the case is known as Malema versus Attorney General. So there were many cases which were consolidated. But even the judiciary felt that it would lose integrity. It would lose something if it did choose Malema as the frontal name for this litigation. That is something. Those are the small honors. Mr. Depress.
I was the first.
Of course. I mean, they have discretion to name it anyway. But they recognize that you filed on the midnight of the passage of the act or something, while other advocates were meeting to prepare. You had your petition on the same day the bill was passed into law. So I tell him that, let's reflect on these 2 greater events for the sake of history. What else can we pivot this success into? I submit to you that you should be frank and honest about money in this work, the place of money. Today we are discussing the place of law. I invited my members to discuss the place of money in fighting the bad laws, fighting bad lawyers who obstruct the people's struggle for freedom and democracy. Because ultimately, stripped to the bare bone, Malema Mabiri's opponents have a lot of money. They are fighting for money. For them, money is at stake, as he has mentioned. They are Binaisa type of lawyers. So I told Malema, we have to study. The difference between you and me now is that I am now thinking about the political economy of this work. At that time, Malema Mabiri objected strongly to the idea, and I want to share this vividly. He told me, Mr. Semakade, you're being crafty. I have heard that you're crafty. I wanted proof. This is it. You're tying on me leopard goat ears to be eaten by the leopard. You said it in Uganda. He's very eloquent in Uganda. I said it's possible, and I agree that that's how you first react when you hear this. But please acknowledge where I'm coming from. I have done this work for more than a decade. You've just done it for a few years. And I would like to hear your objections in a nuanced manner, a structured way, the way you would argue in court. So he gave 3 objections, which I want to restate. He said, number 1, Mr. Semakade, I have my own money. I am a money lender. I am the Secretary General of the Ugandan Money Lenders Association. I am the founder of the Money Lenders Union. I am the legal counsel of the Money Lenders Lobby. So what are you talking about? And in connection to that point, he said, I don't do these things for money like you, an advocate. You advocates think everything is about money. I want to be clear, Makade. Money is the last point in my consideration when I structure a legal battle. That was the first objection by my enemies, to which I had a response which I'll come to later. The second objection is that, Mr. Semakade, you're going to create for me problems. I have now just begun to be understood as a winner, as a fighter for our people. You want to bring upon me a label, a derogatory label of money seeker. This is what, naysayers, our detractors, you're arming our detractors. We are progressing well, and you want us to introduce this concept where our detractors will then pollute community attitudes and destroy our movement. I reject the idea. I dismiss it. The third and last objection, my name is Hart, was that you're opening me up for manipulation by the dictator and his agents. They will change. They will come like they are foxes which will adopt, sheep's clothing, and now come to me through the back door as donors, and use that privileged position to direct me on what I can fight, who I can sue, and who I can't, what I can say. I enjoy this unilateral focus, unilateral freedom, this shoot from the hip, cowboy style. We will now have to offer accountability, write reports, and then we may even have people suing us for, any number of reasons and so on and so forth. So he gave an extensive thesis under that rubric. And I was determined, like I said, to be very selfish in making sure that by the time this conversation is done, my name is singularly the most hated Ugandan. And I sought to persuade him as follows. Regarding the first concern, I told him that, Malay, yes, you are a citizen who is a money lender with a good job. You know, you with your private business. However, every time you engage with the law, lawyers and legal institutions, you apply a specific form of labor for which others earn a living. You know, you set aside your time. If you were a mechanic, you will be setting aside mechanic time, mechanic expertise to learn the civil procedure, to summon precedents, to respond to pleadings written by law firms, to learn on the job. That form of labor needs to be compensated, because if you have a family and he has rejected the notion of family responsibility, but I said, just imagine you will have a family. These people expect you to have some form of, you know, source of livelihood, some form of means, so that this work doesn't interfere with your responsibilities to them. So, on the assumption that if he himself is willing to commit suicide doing this work, he had no response to the idea of what if he made somebody pregnant. Of course, he insisted he uses condoms. Where does he made all sorts of arguments. But I said, on the assumption the condom did work, we don't want to endanger this lady and this child, whatever it is. We are thinking far. I am thinking far. I'm thinking about that child, those children who will be born in the struggle. And here, he acknowledged that I was speaking from vivid experience on my part. And he said he will consider it. So I won. Somehow. The second point, Manisika level. I told him that we all suffer this level anyway. As long as he would stay on the the grinding stone, doing this work, as long as he would be seen doing this work, the detractors will say this anyway. So maybe we shouldn't judge our work by what detractors say. We should be more scientific and objective. And I told him that I felt pained that when I joined this work, there was a narrative that it's highly funded and money exists, and we are swimming in this money. You know, my land brother here, Adrian, is here, and he knows the level properly. That we have game money, lots of it. It can even make a bank. I don't know why we don't own everything in the city. You know? Why would Adrian return to teach, really? You know? So, Marema on this point was very uncompromising. He said, "You're lying. You have perfected this lie. You are one of them." He called us, what are they called? Sausage eaters. You're one of the sausage eaters. I need proof. So we conducted a survey. We got his budget for the age limit appeal. And we saturated it through every civil society organization and their known donors. To the extent we knew. It was a budget of 16 million shillings and we raised 8 million, right? Around there, fair. And so he was able to see that maybe if the money is there, the willingness to give it to you for the work you do, for the cases you've chosen, is not there. They also have agency and autonomy. And so the donor community, the perceived, Western hegemonic donor community, the philanthropic sector that would be the natural ally for this work, is not interested in Mabilis or any citizen of Uganda for that matter. This is very important for you advocates who think that you can join and walk in our shoes. Once you are an independent actor for the interests of the people of Uganda, you are not popular within the philanthropic community. They want a specific kind of native who can accept their so-called log frame matrix, their pre-designed goals, objectives, what to achieve, and everything. What's the word? Tiflo says, the owner, sorry, maybe you are the one here, help me. He who pays the piper calls the tune, yes. Yes, no, so, Mavis had to learn this the hard way. And then he agreed that, okay, maybe now we can democratize the cost of this work. The argument of democratization convinced him a lot, because these two cases filled the airwaves. People on their own, on TV and radio, were asking for Mabilis' number so they can deposit money. So I told him that these are citizens. Most of them did receive an education. Some of them are funding. This is their way of participation. Some of them are in Munyoro. They will never come to Kampala. But they feel represented through you. Give them a platform. So that point is accepted, and I think he began. We now have a word we use after every message. You may have seen it videos. Fundraising continues. The other point about manipulation by Museveni and everything, well, this was the easiest point to convince him against. Because I said, maybe you are many things, but you're not a deity. Not God. You're human. You decay per day. You might fall sick. You might need the assistance of another. Part of this work involves the element of my brother's keeper. We must externalize this beyond lawyers. We must involve the people. Now, the danger of not crowdsourcing money is that you will inevitably think of bigger and bigger money. You will idolize and be infatuated with the idea of a super donor coming to you to lift you out of articulate. What's the English word for that? To unburden you of this load, to lighten your load. Like, for instance, the way you see me, I'm just like you. But you think because maybe I'm an advocate with an office, I must have some resource available for you. I don't actually. I'm giving from the size of my wallet. I'm giving what I have. So, if you don't take our charity, if you don't respond to our good-naturedness, you will actually be the one who opens yourself to the manipulation of power. And you will become a pale shadow of yourself if you look yourself in the mirror. So he put all this consideration and became a devout pioneer in fundraising for our public interest causes. And for that, I would like all of you to send money Malema is well-known numbers. And to send that money frequently, religiously, with pride, with anger, whenever you feel down, send money. Send money. Send money to whatever it has. I don't want to sound blasphemous, but as a religion, send money. You can tithe to whatever it is. So, Doctor, I thought that this anecdote from the comradeship is important. Mavis has been very kind to me. We didn't discuss what he had to say. I'm surprised that my name was in there, in his paper. And in such a title as methodology, he has explained our flamboyant methodologies in a place of honor, like this legal academy, some 30 years. So, and I mean HURIPEC only, okay, it's much older than that. So, the second aspect of our my Malema Mabirizi story is judges as liars. And judges are lawyers. So lawyers as liars is well known, but judges as liars, he has given you the proper thesis for it, but it revolves around contempt of court. And we are happy together. We celebrate this moment because it is the deception of Second that has given both of us this moment. Had there been no liar like Second, Mavis would not have gone to jail, and I wouldn't be president of the Law Society. We would be comfortable filing more cases, not coming closer to a citadel of power. But they left us no option. There was no other way to go but to come and be in charge of legal policy for this country. So our credo and our war combined is against the misuse of the colonial hangover known as contempt of court in a constitutional democracy. Particularly, there are several forms of contempt of court, but the most atrocious, the most insidious harm is known as scandalizing the judiciary, or scandalizing the judge, or scandalizing the court, or which really is so much English for criticizing a judge. Now, criticizing a judge is so embarrassing to the English court which invented this crime that English courts have abandoned it. This is very important. The crime that taught known as scandalizing the judge, scandalizing the judiciary, scandalizing the court, was abolished in England and Wales, in Northern Ireland, and elsewhere in the global north. But judges, English-speaking judges in the global south, especially in India and Uganda, are so devoutly obsessed with maintaining it. And it's very study. Dr. Kawum, this is our heritage to you. Help us. He is the editor of the Mahelo Journal Present. Yes, please stand up for the recognition. Please help us. Help us make the case. You have brought the journal to such an amazing standard. I would like a copy of the present journal for Mr. Malema and myself to take back. If you have, please make some calls. May I know your name, please?
My name is
Julius Ainomishi. Yes. You and your predecessors, you have made us so proud. So the journal is now where we go to Kwaro, where students go to Kwaro on our name, on our behalf. So please focus on scandalizing the judiciary. As Malema has said, we have reached this moment where the judiciary is afraid of the citizen. Are you getting me? And so this doctrinal war should not be lost. I tried on my part to write like Dr. Kawumba. I wrote an article online which you may read. It's titled Voyeurs and Fragile Flowers. Judicial officers must have thicker skins. It was published by the mainstream UG. Yeah, mainstream UG.com or something is there. It was published in the heat of passion. Sometime in February, on the 2nd of February 2022, there is some cosmosis there. We woke up to a headline that the judges have resolved in the 23rd Annual Judges Conference that the number one issue they face as the judiciary is cyber harassment by 2 lawyers, Malema Milisi and Isaac Semakai. Resolution number 1. Then it is concluded by saying that judiciary top management must take action. And judiciary top management has been taking action ever since. To the point that I can't even sit in office. Every time I'm seeing phones are made, summons are brought, so on and so forth. I had to live in exile. It brought a conflict between us. Because Malema was of the view that I should accompany him to jail. To prison, actually. So he has spent the whole year calling coward. Putting me in the same bracket like him, Dr. Kawumba. Simply because 2 days before he was picked up, a colleague of ours, a mutual friend, Mr. Paul Wanyuto, who had fought similar struggles before. Now I told him that Malema Milisi, come and consult from another shrine master. Because now we are, but no, we are. So Wanyuto, Paul, has cases which are readable online. He has come against a similar cloud before, and he has liberty. Let's come and learn some tips and tricks from him. Malema Milisi left his hiding place and came to join us at this party where we felt safe because we are surrounded by what Ugandans call snake queens. We knew that these people didn't know us at all. They just saw 2 men, in conversation, and unmoved by their nyash and everything. So it was a nice place to be. And we were suggesting to Malema Milisi that we should perhaps take internal exile. What you teach your students are deportation. So there can be deportation by diktat of law. But let us deport ourselves from Kampala. I go and live somewhere in eastern Uganda, you go and live somewhere in northern Uganda. And maybe, so the idea was that the state uses, it must apply specific individuals to a manhunt. It can't keep that formation the whole year. At some point, those police officers must return to duty elsewhere. And then, Malema Milisi had us, as I've told you, he's quite a very impulsive thinker. He said the proposal is rejected, but let us eat. This could be the last supper. And so there's a very famous picture of that moment. And in fact, 2 days later, he was picked up. But that afternoon, before he came to see us, he had sent out a tweet which I'll never forget. It was titled "The Constitutional Right to Hide." Did anybody see it? And he was hiding, with his towel. I'm saying some words. I think it's my right to hide. And he made the case that there is a constitutional right to hide. So that particular tweet really offended the police and security establishment so hard they increased the number of officers looking for him. And in fact, in 48 hours, they had their man. He poked the announcer of the leopard. So, anyway, our lives then, you were right, Professor, when you said we are twins. We were Siamese in contempt at that stage. I think actually I was the first counsel for him. I got some relief, and he has explained the rest of the process. But we're not the only victims of this intimidation by courts and fighting back. There's another victim called Ivan Sebaduka, who was imprisoned sentenced to 3 years for writing some correspondence to a court, the apex court, and calling them a council of fools, and laying out his case. But that case in the East African Court of Justice, we shall argue it there. But it's a serious existential question. The courts being unsafe for citizens, as Mavisa said, we are worried, Dr. Kabamba, that instead of transformative constitutionalism, which is the project of the Constitution, which is the promise of the 1995 Constitution and other new constitutions across Africa, for us we are seeing regression. We are having colonial interpretations where judges see themselves as non-citizens, lording themselves over us, instead of servants and custodians of our quarrels and pain, so on and so forth. I want to read from this article, which is online, something that Malema has made, shielding Rotten Tomatoes. With the people as our shield and social justice our spear, we are constitutionally justified to step on the toes of tyrannical judges and magistrates, using social media and other digital innovations to remind these high priests and Freemasons that they are in reality oath-bound servants of the people. Social accountability mechanisms such as judicial watch apps and social media networks are feared by errant judges and magistrates, the Rotten Tomatoes, the Dimwits, and the Deadwood, for this very reason. Traditionally, Rotten Tomatoes, Dimwits, and Deadwood in the judiciary have been able to hide behind the thick red tape of colonial decorum, analog formalism, and excessive proceduralism to commit unspeakable crimes against the people, like declaring Malema a mere busybody, or lacking sufficient interest to question power with impunity. How do you tell a citizen that he lacks a stake in his sovereignty, in the exercise of sovereign power? And you cite a pre-colonial English statute or case. You cite colonial norms that even England has abandoned. That kind of intimidation has got to end. But we shan't win it if you isolate us and reduce us to caricatures as sources of your amusement. No? I'm happy that you smile. It means you're. But send money. Send money. As I speak, you send money. Suddenly, every Kajubi, Okero, and Mugisha can become an active participant in the war against judicial malpractice, simply by clicking, swiping, liking, sharing, retweeting, etc. You don't even have to comment. We should therefore be very distrustful of and actively resist any cleverly crafted resolution or statement by unelected high priests and Freemasons, which will in effect shield the judiciary's rotten tomatoes, dimwits, and dead wood from exposure. This is not how democracy works, my mate. Thank you for that juxtaposition of democracy and militarism. Democracy is about non-conformism and questioning, contrarian thinking and everything. Judicial office is not immune from scandal. Judges can be stupid and can be foolish. Okay? Judges are not infallible or immortal lords. And court decorum doesn't mean that they are above trenchant or caustic criticism on the digital streets. I can translate. We must not criticize judges using the language of the law journal. We can criticize them using any language, all right? Any language, and they should be able to take it as fair criticism. They cannot dictate that, like Justice Judge Sekana wrote in your case, that criticism must come in a reasonable way, in a constructive way. No, it shouldn't. In England, there was a Mabilizi. I forget his name now. But it's a case which comes up when we study scandalizing the judiciary. And I have a paper, on English-speaking judges and liars. I have been afraid to say it, but it's written in honor of an event that happened at the beginning of the year. Grand Mullah, Senior Counsel Abdullahi, Abdel Nasir, yes, Abdullahi, was banished from the Supreme Court of Kenya, together with his partners, associates, employees, and clients. They said anybody who associates with Abdullahi will get no audience in the Supreme, simply because of how Abdullahi conducts himself on Twitter. So I wrote an essay for which I debated to be presented at University of Nairobi, Makerere, but it's finished. Thank you. I have made the case. But anyway, so this war is not even localized, you can see. It's an East African war now. Okay? The cat is already out of the bag. The people are wiser, braver, and more empowered these days. Long jail sentences, astronomical fines, tax warnings, and other mysterious sanctions will no longer deter anyone from the patriotic duty of exposing and combating judicial corruption and judicial sophistry, or BI, or federal court. But these excesses will certainly embarrass the judiciary, lowering its standing in society, which is a classical goal. So the rest of the case is made in this article, to which I invite you. Malema Military has not really spoken deeply about the MTN IPO case. But the MTN IPO case, which occurred sometime, this is October, it began in October of 2021 and it closed in December of 2024. That was the Malema Military the highest hour. Malema Military was conducting litigation on his own terms against this behemoth that had been directed by our civil authority. In this particular case, Malema Military and Museveni were speaking the same language. General Museveni had felt that MTN had eaten our lunch for so long. If there is to be a renewal of their license, they should give some of the lunch to Ugandans. So MTN did this IPO, and an IPO is an initial public offering, the sale of shares, under directive, and the agency responsible for approving the prospectus is called the Capital Markets Authority. So Malema will sue the Capital Markets Authority for doing shoddy work of approving MTN prospectus. Because his own investigation showed that there are no shares MTN is against stealing, as it has been stealing for so many years. But again, it is lawyers who are protecting MTN in stealing from Ugandans. And I played the role of commentator for this litigation, ringside commentator for this litigation. Some of the most interesting internet debris is during that hour. I have asked a friend of mine to send me a congratulatory message, which I sent to Malema Bilizi. When the judge said, we have dismissed the case, for me, I used my own special office as legal rebel to say you have won the case. So, take heart, take heart. I can't find the picture, but those of you who are so good at extracting Twitter history, please look for it. I thought that particular message really answered, because I sent a telex to my colleague in a decolonial manner. So we used the word decolonization because we cast this whole thing was really decolonization, democratization, digital transformation. Mabirizi enjoyed a headline which read that year, MTN sought additional time to sell shares because the IPO had been such a phenomenal failure. It had been undersubscribed, and they gave the reasons to the regulator. Litigation and social media commentary. There was only one litigation by Malema Bilizi and the commentary by Malema Bilizi's fans. And we had done some damage. You know, so Malema Bilizi celebrated it. Of course, I can imagine lawyers who were on brief for MTN. They were under. So this is where the content begins, you see. So you can understand that sending Malema Bilizi to jail isn't really about offending judges. There is an element of foreign imperialism interests that were attached and embarrassed. And the judiciary was supposed to supply itself as a tool for this never to happen again. Thank you, Malema Bilizi, for helping that. I wanted to bring that context. It didn't come out well, and probably it shouldn't, because you have to speak to doctrine. I was commented in that case. I had to complete the circle. Malema Bilizi, in your presentation, you have, by human, infallibility, forgotten to stress Article 127 of the Constitution. And for me, Article 127 underlines the significance of today's inaugural conference on human rights, peace, and social justice. Article 127 of the anybody up there, some geek who knows it? There's money. Yes, speak, try. Please speak louder and with pride. Yes. Bang the table. Stand up and bang the table. Yes. So that was written 29 years ago. 29, nearly 30 years ago. Parliament has written so many laws, but it has refused to write any law under Article 127 to promote the participation of the people in the administration of justice. You can also read Article 4. Article 4 of the Constitution. So Julius, our editor, I hope you're taking notes. Yes. Article 4. Yes. You don't have it?
Okay, promotion of public awareness.
Yes.
The state shall promote public awareness of this constitution by A. Okay. So the state shall promote public awareness of this constitution by A, translating it into Ugandan languages and disseminating it as widely as possible, and B, providing for the teaching of the Constitution in all educational institutions and armed forces training institutions, and regularly transmitting and publishing programs through the media generally.
Joke of the day, right? Joke of the day, bang the table. 29 years. So, what is the place of the law and lawyers in the struggle for freedom and democracy? They inherited two core obligations under Article 4 and Article 127, and they have observed them in breach. And yet they insist that you should recognize them and give them full decorum. They are respectable individuals. Are they? These dogs don't hunt. These dogs don't what? They don't hunt. They are despicable individuals. So, therefore, our convener, the great question of the year, which has been resolved at the ballot at Munyonyo just last weekend. The weekend is the following. We have come to what the French call a cul-de-sac. We have come to the end of the road. Uganda law as a dog will not hunt anymore unless it accepts that there is need for different thinking about these four things: legal education and training. Who gets to determine who becomes a lawyer? How they become a lawyer, what they are trained as lawyers. The second is legal justice. How does one become first and foremost a judge, or a judicial officer, magistrate? How are they checked at their job? The quality of judicial outcomes. Is anybody interested? Who should be interested? Should it be lawyers or citizens? So the third is lawmaking. Who gets to make our laws? How do they write them? In whose interest do they write them? To whom do they owe accountability? Is it lawyers or citizens? Lastly, law enforcement. By the executive, the police, the military, the institutions of law that we've created. The great question of the day is the place of the citizen in this corner, in this box. Is the citizen fully empowered to question outcomes on each of these pillars? Am I setting the question properly? Are our citizens offered a ballot paper where the questions on which they are voting involve the efficacy of the law? Is the law working for them? Is the law achieving justice? Is justice on the ballot? Uganda has 3.3 million, electable positions. At each of those moments when the citizen goes to vote, have the candidates debated justice as the core outcome, of the democratic process? That is something we have to ask ourselves. I'm so grateful that lawyers accepted our 4 days mandate, and they looked, they did soul searching, they reflected, and they said, no, Isaac, we have been failing. Let us try the rebels' way. You know? So we want this bang the table, back on track revolution to reverberate across Uganda, such that citizens can be offered these questions. You know? Mabis has told me that citizens, the lawyers are planning to send citizens away from the courts, contrary to Article 4 and Article 127. This is what they are planning. Had they did been for same academy to count, you know. So we couldn't stay in the trenches as critics, as participants, as litigants. We had to raise these issues as a national emergency. And we encourage you, students, to continue this revolution. So, Dr. Kabomba, there's so much I could say about our keynote speaker, but I believe that God has been great to the two of us, and you have had, you know, the bonhomme, which is really what you are. You're a nice guy. You're a brilliant man. And you have your sense of the right pulse of the nation. This nation has to celebrate more Malay communities and has to create more Malay communities. I would be unfair to you if I were to leave this stage without reading and recommending reading from an essay I came across online when I had to prepare for a similar guest lecture. Sometime in 2021 again, 2021 was really a fine hour for us. Dr. Atim, yes, invited me to address a similar gathering, but it was digital, about almost the same subject. And I found myself having to speak some truth to the students then, and I got worried whether I would ever be invited back to speak such truth to students. There is this notion that you come to law school to study to become advocates. But in that lecture, I made the case that students should abandon being advocates and study law with the determined goal to end up as activists, social activists, social justice activists. Because whether they liked it or not, advocates were on the fall and activists were on the rise. People were finding new ways to seek justice without lawyers, without law. And it's going to be very expensive to remain an advocate. In fact, it's not the truth. So many of you come to the bar thinking that Mabisi has warned you, that you will find great wealth. And you stagnate there because there is no more wealth, to find us right at the bar. However, there is much capacity for impact as Marema is, without even going to LBC. So I made that case then, and I was worried after. Actually, one of the students asked that now, should we go to LBC? These were some of the questions. I got concerned after the questions came. So this paper is called The Distinction Between Lawyers as Advocates and as Activists, and the Role of the Law School Dean in Facilitating the Justice Mission. It is written by James Douglas, who was dean then of Texas Southern University, and it was published in the Cleveland State Law Review, Volume 40, issue number 3. Of 1992. So, this article, I want to read from this article to celebrate your role in convening a meeting of rebels addressing law students for the unabashed project of radicalizing them. This is a role that the author celebrates at page 3 of this article, the role of the Lord Dean. The role of the Lord Dean in promoting the justice mission is to be a leader by example. So he gives the example that in order to promote justice, the dean must strive to involve the students in all aspects of the law school's operations, especially its governance. The dean should request that students serve on the important committees, and I'm happy that Miss Ouma is a student. Are you? Huh? A doctorate student, yes. How about our rapporteur? Same. Okay. That is to say the hiring committee, the rank and tenure committee. With this as an example, the students will better understand that the dean believes that the students, are part of the total law school environment. When I was here as MLS president, I sat on the faculty board. So I participated in these decisions. I saw the debates and, the decorum, how lack of thereof in the faculty board. This article goes further and celebrates you specifically in a passage I wanted to read before I leave. I also believe that the dean sets a good example by being actively involved in various professional associations. If the dean says that service in professional organizations is important, then the dean must set an example by his or her service and involvement with professional organizations. If the dean says that it is important to represent indigent clients, then the dean must in some way set an example by assisting indigent clients, either by taking cases, giving advice, or serving on boards of legal service organizations that represent the poor and the needy. And Dr. Awumba, you have been a dean leading by example. Probably the most important thing a dean can do is to help students understand the relationship and difference between law and justice. I will not go into this because a conceptual thesis of greater import than today, but so many law students will be surprised that law has nothing to do with justice, and becoming an advocate might actually involve you, as might be submitted, in being an agent of injustice for the rest of your career, while non-advocates like Malema are the true champions of justice. I beg to submit.
Thank you so much, Mr. President. Because we are out of time, we should have finished at 2. It's now coming to 3. I will not say so much, but I just wanted to really thank you for your celebration of Mr. Malimesi, of his vigor, of his rigor, of his passion, of his courage, his contribution, his commitment. There's a lot to be said. But it was very, very evident that there was no better person to have celebrated Mr. Malimesi other than his twin, his colleague, his comrade, and above all, his friend in the struggle. So thank you so much for your address. We are going to use exactly 10 minutes for the plenary, and thereafter we shall allow our speakers to address us in about 5 minutes in response to the questions that will have been raised. So I'm starting right now. 10 minutes, please.
Thank you very much. My name is, do we have to say? My name is Ismail Serengeti. I was invited. I'm here with my wife, Susan Bapti. She's I was invited by my friend Isaac to come and attend your presentation, Mr. Mayunizu. I live in the US, and Isaac, I'm a rebel, just like Isaac. I'm a mathematician. I'm a healthcare professional living in Boston, Massachusetts. When Isaac came to the US, Mr. Mayunizu, I want to make context. When Isaac came to the US, I think 2001, 2022, he never realized the potential that he had as a rebel, as a legal rebel. And everywhere we went, from when we went to Harvard, when you are giving your thing to the students with Hillary, I was with him and Hillary. The students were in awe. They would not understand that there is a black man who is putting on dreads that is also smart. And when we went, Isaac was in the, how do you call them in Uganda? Those sneakers that you like. Huh? So he was dressed in a t-shirt, so we go to this very big Harvard podium, and he's, but as a people, as Ugandans, we follow you, and you give us the zeal to continue this fight. For us, we may not face the tear gas, may not face the arrests yet, but there's a lot of fight that we're doing on that side of the continent on behalf of Uganda. So, Mr. Mayunizu, I had to come at a very short invitation, and I'm in awe to be in your presence as a rebel leader. Thank you very much, and I will take another. Thank you.
Thank you very much, moderator. And thank you, Mr. Mayunizu and the President, for coming again here. My question goes to Mr. Mayunizu. I am Chimbo Stanley, LLB3, Chimbo Stanley, LLB3. I had a benefit from the proceedings in your case. I had the benefit from the proceedings in the commonly known case of the age limit. And I like the way you ably and elaboratively discussed the issue of the basic structure doctrine. Therefore, my question is, what is your take on the proposed bill by the Minister of Constitutional Affairs, which inter alia to me disenfranchises the people from voting their president, and rather referring it to the parliamentary democracy? I thank you.
Jambo Michael, both here with students. First of all, the keynote speech was very powerful. If you were in a bar, I think you would have said, Nikibamba sana wapidulo wewe. But by way of recommendation, and I don't mean to undermine, neither do I desire to lead to the unimaginable efforts that you put in the paper, but in the spirit of having less of the Binaisas and having more of the Abu Kachama Mayanjas, can you prescribe a kind of pedagogy in that spirit so that we have less of the Mayanjas and more of the Binaisas? Thank you.
Yes, thank you very much. My name is Katende John Baptist. I'm a second year law student. So mine is not a question, it is a concern that I would like to bring to the attention of the panel. And because it's a serious concern which is seemingly ignored by law students, and I haven't seen any action about it. So the university administration intends to implement new fees policy. So it is for that reason that it is alleged that some students met with some guild leaders at 1 a.m. at Northport to discuss how they will demonstrate in retaliation towards the new fees policy that the university administration wants to implement. So after that alleged incident, warning letters were issued to the guild leaders who allegedly attended the meeting, and suspension letters were also issued to some of the students who allegedly attended that meeting. Now, I interested myself in reading the contents of the suspension letters that were issued out to some of those students, and it really disturbed me that all the contents of the suspension letter, what they had in common is that those students were suspended till further notice, pending investigations. Now, on the surface of it, that is contrary to Article 28 of the Constitution, and it is also contrary to the principle of natural justice, particularly the principle that no one should be condemned unheard, or better put in the maxim, odi alteram partem. Now, to follow up on that matter, because I interested myself, I found out that because this incident, the alleged meeting happened 3 weeks back. Now, the subsequent weeks, most of the schools and colleges were having coursework weeks. Now, by the mere fact that these students were suspended till further notice pending investigations, these students were not able to do and submit coursework. And by virtue of that, that means that they have registered a dead year, moreover, unheard. So my concern is, I tried bringing it to the attention of my colleagues, but they seemed unbothered, and my take on that was that if something has not affected you, or it has not affected any of your relatives, you are not concerned. But as you all know, that provision of being suspended till further notice pending investigations is bound to catch up to any of us in this room. So my question to HURIPEC and the panel is that what do you intend to do about such a provision? Because it is against the rule of law, and it is also a bad law that needs to be struck down. And for avoidance of doubt, I'm also writing an article about it because, as I said earlier, I interested myself in the matter. Thank you very much.
Good afternoon. By the name is Brian Mark Odini, the legal rasta here. I will start by highlighting Mr. Semakade's point where he said we throw away decorum. We perhaps stop being lawyers, rather let's be good citizens. And I really appreciate that statement, and it's in light of Mr. Mabirizi. He has been a very good citizen for the changes he has put out. His cases have been a cornerstone to the law and development in our country. My other comment is we appreciate the two of you, Mr. Semakada and Mr. Mabirizi. Like from the time I had the desire to study law, these were the people we used to refer to. I personally didn't have the belief to go and study law. I didn't, because if you look at my style, I'm a Rasta. Coming to law school, it's something that you'll be segregated or discriminated. And we've seen all this going around in courts of law in community where people are judged for their decorum and not the brains or the work they're putting on for the development of the law. I really appreciate both of you for the good work you've done. And I congratulate our president. Like, this is a true definition of coming. This is a true definition of coming from rags to riches. Because up to now, it's rare to tell someone I'm a law student until they see the work on paper. But Mr. Semakade, thank you for inspiring. Mr. Mabirizi, thank you for inspiring the young generation. Your cases are cited in class. But then a lecturer says, Mr. Semakade is a bright guy but decorum. Personally, to me, that's a demeaning and derogatory statement. Decorum shouldn't be something to beat down someone, because the people we've sent out there, perhaps they have done something, but out there lawyers are being called liars, they are being called thieves. So let's throw away decorum, let's throw away the profession of law, and really just be good damn citizens. I rest my case.
Good afternoon. I'm Semada Ashar, senior first year law student. First, it's my pleasure to be here to have attended a lecture where a keynote speaker is a person that is skeptical of almost everything. He's a guy that is able to swim in waters maybe I cannot even assume someone could swim in. But my question, not a question, my request is, I would like, because you've been speaking fast in your speech, I would like to have, if you don't mind, a soft copy of it. Yeah.
Okay, thank you so much for all your questions. Let's give our speakers 5 minutes each to respond to the questions and comments.
Yes, thank you. Madam Commentator, I didn't want you to repeat questions, giving people 5 minutes when we have spoken for hours. Asimo, before you go, Isaac, I campaigned for Asimo in Marusha before I became when you become vice president. And then before I go to the penalty questions. You know why? I go to Nasimo for prison. I and Nasimo have is the back of what? Yes. Have a background of the upper prison. That's why I supported him. He's not a rich guy. But why I supported him is because he stood with my guys in Upper. In Upper, that word I told you is a special word for classified prisoners. Of course, it's illegal to classify as a prison. It's a prison within a prison. You will tell you that when it comes to Upper, to see his clients, it takes longer than normal. Why? There is what called N2, where they keep classified prisoners. That is me. Terrorism suspects charged with 2021 bombs at Parliament and CPS. There are others who said that we are bombing the neighborhood of Bokech. Hi, Kaluba. So they passed there. And we're not allowed to move out, except with that officer. That officer must be of the rank of ASP and above. Must be a commissioned officer. So during my stay in prison, those were my colleagues, friends. it's a simple prison within a prison. So Asimu became a good lawyer of them. Of course, we dismiss many lawyers, which I won't mention here, because they are not consistent. They seem to be betraying us. But when Asimu came, at least we are able to attack. Okay, let's see work. Let's see work. So he's a true advocate. I think 5 of them, Hamza and others, who were released by Justice Wawin on big trial. Hamza is my good friend. Hamza is a taxi and driver. So that's where I came to know Asimu. And that's why I wanted Asimu to become the leader of that website. Because he understood our struggles in that prison and what we as people need. So I just wanted to organize you. Okay, back to the plenary. I'll start with Mr. Semunoji. I'm Semunoji from Boston. I thank you so much. But I need to point out that I have a big problem with the Ugandans in diaspora, most of them. Ugandans in diaspora disappointed us. Me here, like Asama. It's a few of you. But most of the Ugandans in diaspora are out of reality. They're just excited for nothing, they don't listen to principles. Most of them in Boston. That's why some of us are slow with them. It's difficult to get a diaspora person who understands the principles of governance, strategy, and rule of law. That's why we are less with them. Yes, we can work with Taylor and some few there. But others, noise makers, what no principle. But I'm happy that you have some who can. And that's why you see, we don't relate with them so much. They want that just that noise. Power, noise. Tell them about our principles, no. But I'm happy that you are here. And at least, let you look at the number of people who stand, get more. That's what Chimboa, as a law student, I used to hear, you should avoid speculation and working on romance. There is no such a bill presented by Honorable Norbert Mao to that effect. So wait when he presents the bill, you get a point. But again, if you fraud many agents, best structure was argued, but for guiding based so much on best structure. My argument was a functional replacement. Yes. I thought the structure was a weaker point. My argument was there are some amendments you cannot make because they replace the Constitution as I already them there. But that's speculation. I'll go to Michael. Michael was saying, what should we do? The paper tells you for. Be focused, be on your principles. It is hard to keep on your principles, but if you want to be an application of it's about principles. But when you want to manage it, and power you get it, but it should ban you. Binaisa was banned by the power he got. Within a year, he ran away after destroying the country. Because these dictators will use you, and they will dump you when they no longer need you. When you start wanting to be wiser, they chase you out or you run. John Baptist, about students, I think you are a coward. University students must challenge what they think is unfair. In my paper, I've told you Kasha Mamayanja was dismissed by Ronaldos from this university because he striked against a diet. Did his life end? Ended up being a lawyer. Obote was dismissed from there. Did his life end? So as long as university students think that every time there shall be somebody to fight for you, you are above 18. You are a citizen. If you think something is wrong, fight for it. I remember Isaac Saba represented Jakisa, Vice Chairman of University at Nakawa Court. And I think this is the most example happening as Chamber. And I think that judge was in the what a very good judgment. So plan research and take these steps. We shall not, for us here, we are teaching you how to hunt. We shall not give you the spears. We are busy elsewhere. People need us elsewhere. You know, we need it. So take your steps. The soft copy is available. I'll share it with Dr. Kabomba, and I'll also try to share it as much as possible. Thank you so much for your questions. But moderator, are you having a lecture? After me? You have Richard. Half of it. But don't close our window for us.
And now let's invite
Thank you for your kind words. Most of you gave us appreciation. My response will be to Mr. John Baptist Katende. Is he still around? Yes. Well, you've been told that the concept of a suspension, an indefinite suspension, has already been mitigated. There is a case of Daniel at Chamber University, in which I had some contribution. But there are also others which were litigated against Makerere University's students, discipline regulations as well. And I have, in the last engagement I did with the university regarding suspended students, I didn't even bother with the court. We insisted on, this is what's in Rule 6 or Section 6. We insisted on the students' disciplinary committee convening immediately and providing relief for students who actually ended up sitting their exams. So it pains me to hear defeatist sentiments. You're quite within your place to speak of it as a concern that is fresh and deep, but it's not new and it's not without solution. So what pains me is, why is it that there is no institutional memory within the students' movement? Okay? Why is it that Tewali Musika? Why do you think you're the first student in this university ever in the whole scheme of things? I forget the case students brought to my attention. Some American case, forget the name. Students don't share their rights at the end. Their constitutional rights at the gate of the university. Your admission letter doesn't waive Article 29. And that's a creed you must live by, especially if you're a student. But as Mabili has told you, it has become the way of life now that you all expect to continue burdening us with these things, and then we shall not do anything else concerning real power. So students challenging power is the rightful place of students. Students challenging Mawambi is the rightful place of students. We can support that process. The reason why I stopped supporting students is because they thought it was my job to do this. Maybe I'm overfunded. Actually, we ran out of funds to do this work. We closed that department. We closed it because we have provided all the precedents, you call it. The examples are available, but what we cannot give you is we can't give you principles of citizenship. We can't invite you into your own citizenhood. That's a matter for you to resolve. I think now Angwe can be chased out of the university any day, even now, if students want it. I don't want to sound in support of hashtags, but actually, one hashtag can take him away, only that you lack the capacity to design it. I can design winning hashtags. You can consult me that, but you must be capable, you must be resolute that Nawanga has to go. Okay?
All right, thanks.
Okay, we have come to the end of our conference. I want to invite Dr. Kabumba Musindi once again to come and give closing remarks.
Thank you very much, Mary, and of course the two gentlemen, but I know we are pressed for time, so I'll use about 5 minutes to just say a few things. The first is to thank the HURIPEC staff who have done a lot of work to get this to work. Maxine, Rogers, Dava, Andrew, Margaret, Pius, and of course Mary Auma, Nona Foemongo, and many other colleagues. You're not seeing them here, apart from Lona and Mary, but it takes quite a lot to get this together, and I'd like to appreciate those colleagues of ours. Also like to appreciate, some of them have left, the attendees from the School of Law, our colleagues from the faculty, but also the legal community, colleagues like Professor Bazira, the Principal Emeritus, Madam Rachel Chugozi, Dr. Adrian Jugo also brought Omchomuto, little child, with us. It's important also, I think, for the staff, for children to be involved in these activities. Councillor Aaron Kisa, Councillor Paul Waswa, Dr. Sylvie Namwase, Dr. David Kawada is still here from Sephrod. Thank you so much for staying. And a whole range of colleagues from the legal fraternity, the School of Law community, students, staff, fellow citizens. I'd also like to apologize to our colleagues in Mwasa and Massa and the Makerere University Academic Staff Association Mwasa, the Makerere Administrative Staff Association, and the National Union of Education Institutions. I apologize because we're on strike. The strike was called yesterday, but this event was really too important, I felt, to be postponed. In terms of the date itself and the symbolism of the date, 8th October, and also in terms of the commitments already made by our keynote speaker and the Law Society president. So for that reason, we are, in a sense, by being here, we are not being in solidarity with the staff, and for that I apologize, and I hope that the Mwasa, Massa, and NUI understand the reasons for this exception. But as soon as we leave here, I'm going to be on strike. As soon as we leave the door, the strike will be fully the strike. So my colleagues, Dr. Kapuru, we apologize. The date, the symbolism of today's date has already been mentioned, 8th October. It's 29 years now since the adoption of the Constitution. A lot has been said about it. I will not belabor that. But it's an important day to reflect upon, especially as we get to the 30-year mark next year, as well that Constitution has worked. There have been suggestions as to, and this part of the paradox, should we or can we defend the Constitution which was itself illegitimate from its own conception? But that is a conversation for another day. There's been discussion today about the contempt of court power, and I actually think it's one of those unconstitutional parts of the Constitution. Article 28 clause 12, which says, except for contempt of court, no person shall be. So it just gets this one contempt. It's not then talk about contempt for parliament, contempt for citizens, contempt for the president. It just it gets this one idea and makes it above a very basic constitutional protection of the doctrine of legality. So we accept the challenge to interrogate this further. It's definitely a power that has been abused, and the fear and the danger is that it will continue to be abused if it's not checked. As one aspect of broader abuse of judicial power. The idea of, and now I come to the two gentlemen who have graced us with their presence today. And I think we have been extremely lucky to have these two colleagues here today. A lot of you may not quite recognize what is going on right now, but it's really important that you remember what is going on. Remember this today, remember last week and the previous years. It is not, it's something, it's a very important moment in the history of Uganda's legal profession, where Ugandan lawyers are willing and able to commit class suicide, to say, if necessary, to do justice, if it's necessary to do justice, to abandon the niceties of the legal profession, that will happen. It's a very, very important moment. It's a moment of disjuncture, but it's a moment of reclamation. And I'm glad that we have with us two of the leaders of this moment. And I'm happy that in both of their cases they have chosen to gift us with vulnerability, to share with us their personal stories and about the journey that made them who they are and the dynamic of what they're doing. Professor Lokunyango, who retires this semester and of whom much will be said in the coming year by us and by really the nation, has told us that the personal is political. And there's no better example that the political nature of the personal than the addresses we've had today. So we've had, and we have seen vulnerability, we have seen raw emotion, we have seen an opening of the personal. And these are things that lawyers should be able to do and happy to do. Professor Lokunyango talked about the right to love. I also reflected the right to unlove. We have had our president saying that he invited Council Malay into the company of those who are hated and those who might be hated even more. We have discussed human emotions of love, hatred, envy, prejudice, and those are emotions that the idea of the lawyer as human being, the idea of the lawyer as citizen, is, I think, an important idea that you should not really forget as you take it away, as you go away. The role of money, the idea of being authentic about that, and I can really speak to both of the gentlemen in terms of their authenticity in this regard. When a couple of weeks ago, for the first time since I became a member of Law Society, I sent a small token to the campaign of now President Semakade. And I called him not try because he's and I'm on him. I was struck by something. He said, thank you, but thank you more for the debate. So it was immediately clear to me that this was a gentleman who understood, who placed money in its proper context, not as an end in itself, but as a means to an end. And in the hierarchy, who put it, number one, is the idea of the platform of discussion and debate. And then, thank you, but thank you in the first place for the forum of debate. And the same really applies to Councilor Magris. And I'm glad that this discussion is happening about the political economy of cash and the idea of democratizing fundraising. It's an important one because we cannot get away from the question about donor dynamics and that. So it's really important to indigenize these struggles, and one of the ways to do so. I can see actually fundraising numbers have been put there. So yes, I also repeat the call. By all means, send money to the cause that you believe in. Now, I'll end by reiterating the gift we've just had. Yes.
Dr. Levy, it's time to minute. Martin, come.
By all means, Martin,
Sorry, Doctor.
No, it's fine.
I will use your minute. But I had to call this guy, Obana Mati. Obana Mati, Baba, I always see him. This guy was my personal assistant throughout the prison time. So I think it was unfair. Both to me, both for myself and Isaac, not to recognize him at this moment. And also tell you, since we're the closing person, tell the people that the conversation continues on our social media, mainly X. So those who have been asked, you can ask, I will get time, especially for independence to respond. Thank you so much.
Thank you very much for that, Councillor, and thank you, Martin, for the work that you did. I'll end by again reiterating I think it's the Bible that says the prophets in their own home are not recognized. So we might take these two individuals for granted and just assume that this is how people are supposed to think and this is how lawyers are supposed to think, but it's not. I just like to appreciate on behalf of my own behalf, on behalf of HURIPEC, and I dare say on behalf of the School of Law and the university, to appreciate the gift we've just had this afternoon. In listening to two people who I believe to be two of the most intelligent lawyers we have in Uganda, and both of their stories reflect the same in terms of they're both UNEP certified. But also, I think coming from that, I think the ability to be anti-clockwise thinkers. And that has been demonstrated. So if you were looking for people to aspire to, I end with this as lawyers and law students. Please do not follow the idea of the normal thing. Do not, again, there's really nothing wrong with trying to make some money. One of the students who just finished last year, who is at LDC now, I'll not mention his name, but he was enamored by the whole corporate thing until LDC locked them out. Then he said, I've been here working about corporate law, but now we're now dealing with things we learned in jurisprudence about legal education, legal profession. As a lawyer in a third world country, you can't escape having to deal with bad governance and what comes with that. So my invitation to you all, yes, aspire to make some money. But if you're looking for people to aspire to, if you're looking for heroes, we have had them today, we have listened to them today, learn from them, follow them, be like them, and Uganda's legal profession may have a chance of salvaging itself. With that said, I thank you all, and I cannot say happy independence because that's the discussion we're having also as HURIPEC in terms of, I cannot really say, but the Ugandan project is alive and well, but the Ugandan struggle is even more alive and even more urgent. Asanteni.